Supplementary list, item number 1.
Lordship, I'm through virtual mode.
Yesterday, I have received that copy, IA copy,
Yes.
at a late hour, and no document have been annexed to it.
Lordship, death certificate has not been issued yet. I have got information from the family that it will be issued in afternoon today. Since government works takes some time, but since we have set it on the affidavit, so there is no reason to disbelieve the statement.
No, it is has to obtain the instruction from that. Which police station is?
This is
Tunda police station. Tunda
Mahali,
police
but
station.
the petitioner is from
Karnal.
outside, UP.
No, Lordship, it's from Haryana.
Haryana.
Lordship, it's from Haryana.
What is the name of the police station?
Lordship, police station is TUNDA, Tunda.
It is not mentioned in the cause title.
Lordship, in the bail application, it's mentioned, but the word PS is missing. Tunda has been mentioned twice, but the word PS is missing.
No, in the cause title, the
Different police station is.
police station is not reflected. So correct it, mention the police station name correctly, and local securities document give, so that all these things should be done.
Local
IN number 1526 of 2023. There is an application for interim bail. On the ground that the father of the petitioner was diagnosed from lung cancer.
Lung cancer.
And he has passed away on 19/11/2020. 17/11/2023. And the death certificate has not yet been received, and the presence of the petitioner is necessary to perform the rituals, last rites of his father. The learned counsel for the state submitted that he received the interim application yesterday in the late hour, for which he couldn't obtain instruction about the correctness of the averments taken in the interim application, and he may be given some time in that respect. The learned counsel for the petitioner submitted that the petitioner's address has been mentioned in the cause title. However, the police station has not been reflected, and the concerned police station is, which is that police station?
Lordship is TUNDA, Tunda. Tunda word has been used in the cause title, but the word PS is missing.
Where have you mentioned Tunda in the cause title? You have mentioned Sandeep.
Sandeep, the name of the petitioner.
Sandeep, 25 years. Then what is the full name has not been? What is the surname?
Nothing. Only Sandeep.
Okay.
The FIR is registered on the
son of Shatbir, resident of 421 ward number 30, Dhera, Pana, Meham. But where is the you have mentioned Tunda police station?
It's Meham. Sorry, I'm really sorry. It's Meham, Lord. Sorry, it's Meham is the police station.
Okay.
Meham.
Belong to Meham police station.
Meham PS.
Okay. And you will also furnish the documents up to local sureties to the learned counsel for the state, which will be verified by the learned counsel for the state to the inspector in charge of Mathili police station. So, Mr. You let the superintendent of police of Malkangiri
Yes.
make necessary communication with the superintendent of police of Rohtak,
Rohtak.
right?
Yes,
That
Yes, Lord.
Rohtak in the state of Haryana for ascertaining the correctness of the averments taken in the interim application relating to the death of the father of the petition. Immediately, when you will supply those documents,
Lordship, till evening,
okay.
today itself.
Acha, is land council submit that the documents will be supplied during course of this today, during course of the day to the land council for the state. So let it come on Friday. I'm keeping this matter.
Lordship.
So, put up this matter on 1st of December 2023. Free
Lordship, can
copy
it
of
be
the
taken
order
on
be
supplement?
handed over to the land council
Lordship,
for this.
I request to be taken in a supplementary. It's
Okay,
otherwise,
it will come in the supplementary
please.
list.
I'm obliged, Lordship.
Yes.
I'm obliged.
Next.
Item number 2,
May I please?
instructed to issue notice the deponent regarding the affidavit, my lord. Why the proceeding against the contempt of court act is not initiated
The
against?
application has been filed for interim bail on the ground that the marriage of the sister of the petitioner is going to be solemnized on such and such. The invitation card for the marriage has been annexed to this. State was asked to obtain. Today, Land Council for the state has produced the report dated so furnished by the inspector in charge of Model Police Station, Shahadev Khunta Baleshwar, which indicates that the marriage of the sister of the petitioner is under process. However, the mother of the petitioner could not say about the name of her son-in-law and could not provide the marriage invitation card, and she further stated that Dolly is not her daughter's nickname. Rather, Dolly is one of the friends of her daughter who has already got married, and therefore there is no truth regarding arrangement of marriage of Namita Sethi with Vikas Sethi, which is stated to be held on 24/11/2023. The report is taken on record. It appears that a false affidavit has been filed before this court by the mother of the petitioner for the purpose of grant of interim bail to her son. Issue notice to the deponent Jayanti Sethi. Deponent in the affidavit of this interim application as to why so and so. But a free copy so and so. Yes,
Yeah,
what is
my
that?
lord, deponent has come, my lord, his mother. So he said that Dolly is his nickname. Dolly is nickname, but due
Where is
to
your IAC?
ISC ଖାଲି communicate କରିବା ପାଇଁ କୁହାଏ and it was communicated.
So, what is the identity proof that she is the Jayanti Sethi?
He has brought him. Petitioner has brought him.
Huh?
Petitioners have brought him.
Aadhaar card.
We have only communicated that thing to.
What document you have that she is the?
Aadhaar card.
Where is the original? Yeah. कौन हला तुम आगू का माइक तो एडजस्ट करो
Okay.
ये जो सत्यपाठ आपण करथिले
ଆଜ୍ଞା
प्रभात सेठी आपणकर कोन हबो
ପୁଅ
आपणकर पिलापिली केतटी
ଝିଅ ଗୋଟେ ପୁଅ ଗୋଟେ
हम
ଝିଅ ପୁଅ ଦିଟା
जियो ना कोन
ନମିତା ସେଠୀ ଡଲି ସେଠୀ
से कोन करूची
ସିଏ ଇଲେକ୍ଟ୍ରି ଅଫିସରେ ଅଛନ୍ତି
किए
ଝିଅ
इलेक्ट्रिक ऑफिस रे चाकरी करछन्ती
ଆଜ୍ଞା
पिलापिली केटी आपणकर जियोर
ନା ନା ବାହା ହେଇନାହାନ୍ତି
हम
ବାହାଘର ତ ପୁଅ ତ ଭିତରେ ରହିଛି ଜେଲ ଆଉ ମୁଁ ତ ବିଧବା ସାର୍
हम
ଆଉ ଏପ୍ଲାଏ କରିଥିଲି ପୁଅକୁ ଟାଇମ ବେଲ କାଢିବା ପାଇଁ
हम
ଟାଇମ ବେଲ ବାହାରିବି ନା ମୁଁ ବାହାଘର କରିଥାନ୍ତି
हम
24 ତାରିଖ ବାହାଘର ଥିଲା ବାହାଘର ବି ଭାଙ୍ଗି ଯାଉଛି ସାର୍
हम
ବାହାଘର ବି ଭାଙ୍ଗି ଯାଉଛି
हम
ବାହାଘର ବି ଝିଅରେ ହେଇପାରୁନି
हम
ପୁଅ
बागर
ସିନା
बागर का संगे रही थांदा
ବିକାଶ ସେଠି
कोठी आर से
ସିଏ ହଉଛି ରହିଛନ୍ତି ଯେ ଯୋଉ ତାମ୍ବୁଳିଆ ଗେଟ୍ ପାଖରେ ଭଡା ଅଛନ୍ତି ତାଙ୍କ ଘର ଜଳେଶ୍ୱର ସିଏ ବର୍ତ୍ତମାନ ଅଛନ୍ତି ଏଠି ବାଙ୍ଗାଲୋର
ज्वाई कौन करे ଆପଣଙ୍କର ଯିଏ ହେଇଥାନ୍ତା ଜ୍ୱାଇଁ
ଆଜ୍ଞା
ଆପଣଙ୍କର ଯୋଉ ଝିଅ ଜ୍ୱାଇଁ ହେଇଥାନ୍ତା ସେ କଣ କର
ସିଏ ପ୍ଲାଣ୍ଟରେ କେଇଠି କାମ କରୁଛନ୍ତି ବାଙ୍ଗାଲୋରର।
ତାଙ୍କ ବାପାଙ୍କ ନାଁ କଣ?
ତାଙ୍କ ବାପା ନାହାନ୍ତି।
ବାପା ନାହାନ୍ତି?
ନା
ତାଙ୍କ
ମା
ବାପା
ଅଛନ୍ତି।
ତାଙ୍କ ବାପା ନାଁ ବି ଜାଣିନାହାନ୍ତି
ନା
ଆପଣ?
ଝିଅ ତ ଭଲ ପାଇଛି ନା ସାର୍, ମୁଁ
ହୁଁ।
ଜାଣିନି କେମିତି ସେଇଥିପାଇଁ।
ଏ କାର୍ଡ କୋଉଠି ଛପେଇଲେ?
ଝିଅ କହିଥିଲା, ଝିଅ ଛପେଇଥିଲା
ହୁଁ।
ବାହାଘର ପାଇଁ।
କେତେଟା କାର୍ଡ ଛପେଇଥିଲେ?
ଗୋଟିଏ।
ଗୋଟିଏ କାର୍ଡ ଛପେଇଥିଲେ।
ଆଉ ପୁଅ ବାହାରି ଥିଲେ କାର୍ଡ ଫାର୍ଡ ଛପେଇକି ବାହାଘରଟି ହେଇଥାନ୍ତା।
ଗୋଟେ କାର୍ଡ ଛପେଇଥିଲେ ଏଇ ଯୋଉ ବେଲ ଯିବା ପାଇଁ, ଜାମିନରେ ପୁଅକୁ ନବା ପାଇଁ ଗୋଟେ
ଆଜ୍ଞା।
କାର୍ଡ ଛପେଇଥିଲେ।
ଆଜ୍ଞା।
ଆଉ ବନ୍ଧୁବାନ୍ଧବଙ୍କୁ ଡାକି ନଥାନ୍ତେ?
ନା ଡାକିଥାନ୍ତି, ପୁଅ ତ ବାହାରି ନାହିଁ ନା। ପୁଅ ତ ଯାହା ବାହାରି ଥିଲେ ଯାହା କରିଥାନ୍ତି। ଆଉ ମୁଁ ତ ସାର୍ ଲୋକଙ୍କ ଘର କାମ କରୁଛୁ, ବିଧବା। ପୁଅ ତ ସିଆଡେ ରହିଗଲା।
ପୋଲିସ ବାବୁ ତଦନ୍ତ କରିକିନି କହିଲେ ଯେ ଆପଣ ଯୋଉ ସତ୍ୟପାଠ ଦେଇଛନ୍ତି, ସେ କାର୍ଡ ଦେଇଛନ୍ତି, ଏଗୁଡା ସବୁ ଜାଲିଆତି। ଆପଣଙ୍କର ଝିଅର ଡାକ ନାଁ ଡଲି ନୁହେଁ।
ହଁ,
ଆଉ
ଡଲି।
ଡଲି ହଉଛି ଆପଣଙ୍କର ଝିଅର ସାଙ୍ଗର ନାଁ। ଆଉ ସେ ସାଙ୍ଗ ଡଲି ଯିଏ ବାହା ହେଇ ସାରିଲାଣି। ଆପଣଙ୍କର ଝିଅର କୋଉଠି ବାହାଘର ଫାଘର କେବେ ଠିକ ହେଇନି। ଏଇ ସବୁ ପୁଅକୁ ବେଲରେ ନବା ପାଇଁ ଗୋଟେ ମିଛ ଶପଥ ପାଠ ଆପଣ କରିଛନ୍ତି କୋର୍ଟରେ।
ନା ସାର୍, ମୁଁ ଯାହା କହୁଛି ସତ କହୁଛି ସାର୍। ମୋ ଝିଅର ବାହାଘର ଭାଙ୍ଗି ଯାଉଛି।
ହୁଁ।
ବାହାଘର ଯେ ପୁଅ ବି କହୁଛି ଯେ ତୁମ ପୁଅ ନ ବାହାରିଲା ପର୍ଯ୍ୟନ୍ତ ମୁଁ ବାହା ହେଇପାରିବି।
କାର୍ଡଟା କାଇଁ ଛପେଇ ଦଉଥିଲ?
କାର୍ଡଟା ଛପା ହେଇଥିଲା।
କାର୍ଡ ଗୋଟେ କାର୍ଡ କୋଉଠି ଛପା ହୁଏ?
ସାର୍ ଶୁଣନ୍ତୁ, ମୁଁ ଏଇ ପୁଅକୁ ବେଲ ନବା ପାଇଁ ମୁଁ ଛପେଇଛି।
ହୁଁ
ମୋର ଭୁଲ ହେଇଯାଇଛି।
ହୁଁ। କଣ କରିବ ତାହେଲେ? କୋଉଠିକି ଯିବ? ଚୌଦ୍ୱାର ଯିବ ନା ତମର ସେଠି ଲୋକାଲ ଇଏରେ ରହିବ? କୋଉ ଜେଲକୁ ଯିବ କୁହ? କାଇଁ ଏ କାମ କଲ?
ସାର୍ ମୋର ଭୁଲ ହେଇଯାଇଛି।
ହୁଁ?
ଭୁଲ ହେଇଯାଇଛି।
ପୁଅ ତ ଜାମିନ ଆବେଦନ କରିଛି, ତାର ଜାମିନ ଆବେଦନର ବିଚାର ହେଇଥାନ୍ତା। ଏଇ ଯୋଉ ବାଟ ଯୋଉ ତମେ କାହାର କିଏ ତମକୁ କହିଲା ଏମିତିଆ କାର୍ଡ ଛପେଇକିନି ଏମିତି ସବୁ? ଓକିଲ ବାବୁ କହିଲେ ନା ଆଉ କିଏ ସେଠି କିଏ ଆପଣ ତମ ଲୋକାଲିଟିରେ କହିଲା ଏମିତିଆ କଲେ ପୁଅ ବାହାରି ଯିବ?
ଏଇଟା ସତ କଥା ସାର୍। ଝିଅର ବାହାଘର ଅଲରେଡି ଠିକ
କିଏ
ହେଇଛି।
କହିଲେ କହୁଛନ୍ତି?
ନା କେହି କହିନାହାନ୍ତି।
ହୁଁ?
କେହି
ତାହେଲେ ତମେ ଏଇଟା କରିଛ ନା? ତମେ ଆଉ କାହା କଥାରେ ପଡିନ, ତମେ
ନା।
ତମ ବୁଦ୍ଧି ଖଟେଇକିନି କରିଛ।
ବାହାଘର
ବୁଦ୍ଧି ଖଟେଇ କରିଛ, ତାହେଲେ ଭିତରୁ ଯିବ ଆଉ କଣ? ମିଛ ଆଫିଡେଭିଟ ଦେଇଛ, ସତ୍ୟପାଠ ଦେଇଛ, ତମ ବୁଦ୍ଧି ଖର୍ଚ୍ଚ କରିକିନି କରିଛ। ପୁଅକୁ ଜାମିନରେ ନବା ପାଇଁ ଗୋଟେ କାର୍ଡ ଛପେଇକିନି ଆଣିଛ। ଝିଅର ବାହାଘର ଠିକ ହେଇନି।
ସାର୍,
ହଁ।
ବାହାଘର ହେଇଛି।
ହୁଁ
ବାହାଘର ଭାଙ୍ଗି ଯାଉଛି ନା,
ହୁଁ
ପୁଅ ତ ଭିତରେ ରହିଛି।
ହୁଁ।
ମୁଁ ବିଧବା ଲୋକ, ମୋର ତ କେହି ନାହାନ୍ତି। ମୁଁ କଣ କରିବି?
ତମର ବାହାଘର ଯୋଉଠି ଠିକ ନ ହେଇଥାଏ, ସବୁ କିଛି ଇଏ ନ ହେଇଥାଏ, ସେଠି ଗୋଟାଏ କାର୍ଡ କୋଉଠି ଛପା ହୁଏ?
ଶୁଣନ୍ତୁ ସାର୍, 24 ତାରିଖ ବାହାଘର ହେଇଥାନ୍ତା। ବାହାଘର ଭାଙ୍ଗିଗଲା।
ହୁଁ।
ସେ ପୁଅ କହୁଛି ଯେ ତୁମ ପୁଅ ନ ବାହାରିଲା ପର୍ଯ୍ୟନ୍ତ ମୁଁ ବାହା ହେମି।
You file an affidavit, otherwise I will send her to custody. Hello? It's absolutely a false affidavit. Hello? This card has been created just to get the bail. ଅଦାଲତ ଅବମାନନା ତମେ କରୁଛ ସତ୍ୟପାଠ ନାଁରେ ମିଛ ଆଫିଡେଭିଟ ଦେଇକିନି। ସବୁ ପୋଲିସଙ୍କର ଇନଭେଷ୍ଟିଗେସନରୁ ଏନକ୍ୱାରୀରୁ ଜଣା ପଡିଲା। ତମେ ବି ନିଜେ କହୁଛ ଯେ ଗୋଟାଏ କାର୍ଡ ଛପେଇଥିଲ ବୋଲି। ତମ ସମୁଦି ଅଛନ୍ତି ନା ନାଇଁ? ଆଉ ସମୁଦି ନଥିଲେ କେମିତି ଲେଖିଦେଲ ଶ୍ରୀଯୁକ୍ତ ଶରତ ସେଠୀଙ୍କର ଜ୍ୟେଷ୍ଠ ପୁତ୍ର? ଯିଏ ମରିଯାଇଥାଏ ଏମିତି ଲେଖାଯାଏ?
ମୁଁ ତ ପାଠ ପଢିନି।
ସେ ରହିଲେ ସେଠି ଭିତରେ ରହିଲେ ସବୁ ଠିକ ହେଇଯିବ, ଯେ ବୁଦ୍ଧି ଆସିଯିବ। ଯେତିକି ବୁଦ୍ଧି ଆସିଥିଲା ସେଠୁ ଆହୁରି ବହୁତ ବୁଦ୍ଧି ଆସିବ। ସେଠି ଯୋଉମାନଙ୍କ ସାଙ୍ଗରେ ମିଶିବ ସେମାନେ ଆହୁରି ବୁଦ୍ଧି ଦେଇଦେବେ। File whatever you want to do. I'll take up this matter afterwards. Yes, next.
I beg your pardon to make mention, my lord. Weekly list. Item 112.
Wait. What do you want?
My lord, I have for bail. My lord.
I'll go serial. Yes, call the man.
My lord.
Weekly list item number 19.
In item 19, let's say I am appealing.
Twenty-four.
Notice was served, but to CD not received.
କେବେ notice ସର୍ବଲା?
Notice ସର୍ବଲା 26/11/23.
So we'll take up on 4th.
Yes.
The Learning Council for the state submit that notice on the informant has been made sufficient. However, he is yet to receive the case diary. So also the instruction about the criminal antecedent of the appellant, if any, put up this matter, we commencing from 4th December 2023.
Item number 25.
Notice served and CD also available.
Pass over.
Item number 26.
CD is not available. Notice served.
Notice, sir.
Yes.
All right.
27/11.
But I'm calling the next week. The Learning Council for the state submitted that notice has already been made sufficient. on the informant on 27/11/2023, and he is yet to receive the case diary. Put up this matter in the week commencing from 4th of December 2023.
I may be pardoned, my lord. Item 23, my lord.
Yes, call the matter 23.
Item number 27.
23 पर अखबाला
23.
Item 23.
who list તમે કાઢી છે division bench ର କଣ କାଢି କଣ କୋଉଠୁ ଧରା ହେଇକି ସବୁ ଆସୁଛନ୍ତି Yes, Mr. Samantray.
My lord.
This is your first application or earlier rejected?
My lord, first application. My lord.
Oh, what is the date of custody?
My lord, custody since 3/9/2023.
Charge sheet submitted.
My lord.
What are the offenses?
My lord, offense 419, 420, 34 of IPC, read with section 66, C 66D IT Act, my lord.
C and D, D for Delhi.
My lord.
What is the allegation against you?
My lord, the informant is 40 years widow lady, my lord. She was having a relationship with the present petitioner, my lord. And there is a long standing relationship between them, my lord. And thereafter, she denied to marry the present petitioner, informant, my lord. And there was a meeting in the village, my lord. The 161 statement states so. There was a meeting and she did not come to the meeting. Thereafter, she filed this affair, my lord. And moreover, my lord, the lady is...
Charge sheet not submitted under 376, etc.
No, my lord.
So what happened to the pregnancy, Mr.
That instruction. The other day, your lordship has directed to this.
Directed, my lord has directed. As per my information, my lord, she delivered a baby, my lord, child.
Any other criminal antecedents?
No, my lord.
No, my lord.
Why this 66C and D were charge sheeted? You were charge sheeted? What allegation is there?
No, 164, there is no allegation.
No allegation. And custody I have said wrongly, my lord. 17/4/2023, my lord. Custody since.
17/4.
My lord.
And the offenses under which you said charge sheet submitted,
my
are
lord,
those
that is
correct offenses?
No, my lord, sorry, my lord. In the 493, 417, 506 IPC, read with section 32B of the SC/ST PA Act, my lord. That is the charge sheet, my lord. Charge sheet submitted
There
on
is- in the charge sheet, there is no 66.
no, my
And
dear.
Say some other case is submitted.
My
So
lord.
what are the offenses?
My lord,
Offenses is
490.
according to charge sheet 417, 493,
Yes,
506,
yes.
32B, 31S, 32BA of SCST Act.
SC/ST.
Notice is sufficient.
Yes, madam.
The Learned Counsel for the state has produced the written instruction received from the officer in charge of Kaprakol Police Station, Balangir, as per the order dated 13/11/2023, to the effect that the victim delivered a child and gave her child to one couple of village Deoga under Balangir district soon after the birth of the child, as she and her mother were incapable of taking care of the child. The Learned Counsel for the appellant submitted that the appellant is in judicial custody since 17/4/2023 and he is having no criminal antecedent, and he has been charge sheeted under section 493, 417, 506 of the Indian Penal Code, section 31S and 32B bracketary BA of the SC/ST POA Act. And it appears from the statement of the victim, who is aged about 36 years, that she was a consenting party, and therefore the bail application may be favorably considered. Learned Counsel for the state has produced the case diary, placed the statement of the victim. Considering the submission made by the Learned Counsel for the respective parties, nature of accusation against the petition, the 164 CRPC statement of the victim, period of detention of the petitioner appellant in judicial custody and absence of any criminal antecedent, I am inclined to release the appellant on bail subject to condition that he shall not try to come in contact with the victim and shall not try to tamper with the evidence or indulge in any criminal activities. Violation of any terms and conditions shall entail cancellation of bail. It taken on record कर दो, है ना?
Highly obliged, my lord.
Item number 27.
The 19 was passed.
19
was passed.
19, अच्छा 19 तक देखो.
Item number 19.
20, this is CRLA number 8. Outre,
In this case, notice has not sent.
which one?
Item 27.
SCST matter?
Yes.
On the ground of a delay, the notice was issued, my lord, and also filed the requisites for issuance of notice to the opposite party for registry post, my lord.
So what happened that
He has filed the registered post.
And also copy of the state council to that sub upon the
Mona Gurjin?
Nine, copy 9.
The Learning Council for the state submitted that
ସେଟା କଣ ହେଲା ସେଟା register post
ପଠେଇଛି ପରା
ପଠେଇଛନ୍ତି ତ ସେଟା କହିଦଉନାହାନ୍ତି
the notice ଟା ପଠେଇଛି that may be my lord issued by the it is
ଆସିଲା କି କିଛି back କର?
lately filed it's filed lately that may be issued my lord the
ସେଟାକୁ ଅପେକ୍ଷା କଲେ ଡେରି ହବ. Why don't you serve another copy?
yes my lord total sum in course of the day
The no intimation has been received. No, the Learning Council for the appellant submitted that even though the order was passed on 7/11/2023 for filing requisites for issuance of notice to the opposite party number 2 by speed post with proof of delivery, but he filed the requisites a little late. Let a copy of the interim application that is IN number 2670 of 2023 be served on the Learning Council for the state during course of the day, which will be sent to usual court level as a police station IIC for its service on the informant. Hello? Baki case diary you have received?
yes
Learning Council for the state submits that he has received the case diary. So also about the instruction about the CA,
yes
criminal antecedent.
he is 8 years in custody
Uh,
the appellant is custody since last 8 years the status report was called for
that is there. That is available. Only this formalities is to be, so it will come on 11th of December 2023.
I will serve by the appeal memo along with the my lord discuss
Yes.
the limitation both
All right, limitation, IA copy along with the appeal memo. Hello?
my lord
This one, yeah.
Item number 28.
name টা reflect লিখে and in the top of the brief also দুইটা জায়গা Item number 30. Mr. Das, what is your item number? 180, 180, 118. Bring that file, Mr. Tripathi. 118. Yes. Item 30, notice sufficient.
No, Miller. Confirmation letter not received.
Somebody has already entered appearance, Mr. Ajit Kumar Panda. So you have received the case diary?
Yes, Miller. Case diary.
Then I'm passing it over. Yes, next.
Item number 31.
31, Lord. May I permit to conduct the case through BC, Lord?
Yes.
Lord, here is an appeal against.
CD available?
No, Miller. CD and confirmation letter also not.
No, confirm is appear kar jayi. Jagabandhu Sahu is appearing for the.
I'm appearing on behalf of Jagabandhu.
Okay, it's all right. No, you have not received the case diary.
CD.
So get it. It will be taken up on 4th.
Yes.
The Land and
Three
Council.
occasions, Lord, in the last occasion also, your Lordship. 3 occasions they are taking time.
CD ପାଇଁ କଣ 3ଟା time ନେଇଗଲାଣି ଆପଣ?
ଆଜ୍ଞା। ଏକ ଗୋଟେ ଲାଷ୍ଟ ଆଗ ଯାଇଥିଲା 14/11 ରେ.
List this matter on 4th of December 2023 as paid for by the Land Council for the state to get the case diary as well as to obtain instruction about the criminal antecedent, if any, against the appellant. Yes, 4 तारीख ଆସିବ.
Item 32.
May I please, madam?
Available.
CD available.
Let pass over. Yes.
34, it's a pass over, my lord.
Item 34.
34 ରେ notice sufficient ହେଲା.
32. This is a connected case.
କୋଉଟା?
ଏଇଟା ଗୋଟେ.
1102 ଆଉ 1103 connected case?
Yes.
Okay, pass over.
Item 35.
35, Mr. Bhondev. Confirmation letter ଅଛି?
Yes.
Oh, somebody has already entered appearance. Okay. You have got the case diary also?
Yes, Miller.
Yes. You have to argue this matter?
I am for the informant, madam.
আচ্ছা তাহলে pass over করছি নাহান্তি council নাহান্তি. I'm passing it over. Yes, next.
Item 36.
Yes.
The confirmation letter not received.
CD?
CD also not received.
Yes, my lord, I have mentioned and
ତିନିଥର ସମ
Aye.
CRLA 1131. Order ତ ପ୍ରଥମ order ତ pass ହେଲା 30/10/2023 ରେ. ତାପରେ second order ରେ ହେଲା
14/11.
14/11 ହଁ ଆପଣ କହିଲେ ଯେ extra copy ପାଇକିନି ପଠେଇ ଦେଇଛନ୍ତି ବୋଲି. ତ ଏଇଟା third date ରେ ବି ଆସିଲା 21/11. So offense କଣ?
And 300 co-accused also released on bail.
ଆଉ ଆଣନ୍ତୁ ନହେଲେ ଆଉ ଦେଇ ହବନି ସମୟ.
Yes.
The Land and Council for the state sixth time till next week to obtain the case diary and also instruction about the criminal antecedent, and so also to get the confirmation later regarding service of notice on the informant. Land Council for the appellant opposed to such prayer and submitted that the case has already suffered 3 adjournments. List this matter in the week commencing from 4th December 2023. Made clear that no further adjournment shall be granted. Yes.
Item number 37.
Item 37, my lord, I pray for a passover.
ରୁହନ୍ତୁ ଟିକେ. Confirmation letter ଅଛି?
ନା କିଛି ନାହିଁ ଆସିନି.
CD ବି ଆସିନି?
ନା.
ଏଟା notice ଯାଇଥିଲା?
ହଁ ଯାଇଥିଲା 16/11
Okay, right. All right. Land Council for the state seeks some further time to obtain the confirmation letter, case diary, as well as instruction about the criminal antecedent. This matter on 4th of December 2023.
Item 38.
Achyutananda Patnaik. Adhir kon hela confirmation letter? Mr. Tripathi,
Yes, sir.
confirmation letter paile?
ନା କନଫର୍ମେସନ ସିଡି ଟା ପଳେଇ ଦେଇଛନ୍ତି.
CRLA 1154/2023.
Yes, sir.
CD ପାଇଛନ୍ତି?
ସିଡି ପଠେଇ ଦେଇଛନ୍ତି.
Case criminal antecedent?
ନାହିଁ.
ନାହିଁ. ନା instruction ବାଜି ଯାଇଛି ତ?
ହଁ ହଁ
ବାକି ରହିଲା ଖାଲି confirmation letter.
କନଫର୍ମେସନ ଲେଟର.
All right. The Land and Council for the state submit that he has received instruction about the criminal antecedent, so also the case diary, but the matter may be taken up next week in order to obtain the confirmation letter regarding service of notice on the informant. List this matter on 4th December 2023.
Item 39.
CD, CA ଏବଂ confirmation letter ତିନିଟା ଯାକ ପାଇଁ ରହିଲା 4/12/2023. Yes.
Item number 41.
May I please your lordship?
Just a minute. Notice sufficient?
Yes, notice has been sufficient since 25/11/23, Your Lord.
And you have received the case diary?
Yes, Your Lordship.
Is it your first bail application?
Yes, my lord. First, ABL appeal has been filed, my lord.
That's a different matter.
Yes, my lord.
What is the date of custody?
My lord, the appellant is in custody since 10/10/2023.
What about charge sheet?
My lord, charge sheet has already been submitted. Annexure number 4, running page 28, my lord, 12/9/2023.
P76 2N 417, then 31R S, then 32V and VA. Okay. What is the age of the victim?
26 years.
Wait. Mr. Misra, have you got the statement of the victim?
Lordship, 164 statement I don't have,
Yeah.
but she has deposed in 164. That is as per the rejection order. But in the 161 statement, she has alleged that the accused called her to Burger and then mixed some intoxicants in her drink, and after that proceeded to sexually assault
No,
her.
it's all right, but the 164 should be a part and parcel of
Yes,
the case diary.
should be, Your Lordship.
So, get it, we'll take up this matter on Monday.
Lordship.
The Learned Counsel for the state submits that though he has received the case diary, but the 164 CRPC statement of the victim, which has already been recorded as per the case diary, is not available, and the matter may be taken up next week. Please this matter on 4th of December 2023. 164 statements, CRPC statement be obtained in the meantime. Yes.
Obliged, my lord.
Item 43.
May I please your lordship? Notice was issued in this case, my lord.
Wait. Yes.
I've received the case diary, but about the notice
Confirmation later.
confirmation I've not. But I've informed the IAC over telephone just now, Your Lordship. So if Your Lordship may pass over, I might get it in the second half, Lordship.
No. He has to be given some time,
Lordship.
for engaging the counsel. So,
Lordship.
if he serves even today, I cannot take up the matter. At least 1 week is to be given to the informant to engage his counsel. Okay. So, the Learned Counsel for the state submits that he has received the case diary, but the confirmation later regarding service of notice on the informant is awaited. Put up this matter on 4th of December 2023. Yes.
Item 45.
Mr. Sahu. Notice has been issued.
No, on the date, just a minute. On the date of occurrence, he was in jail in Surat. I am giving the copies.
No, it's all right, but the mandatory requirement is to hear that informant because it's a 3A CST matter.
Well, that is all right, but he has to also take instruction on
Just
this.
I'm
Both
the extra copy of the appeal memo be served on the Learned Counsel for the state.
46, 47.
You serve it by tomorrow.
Just now.
Just now.
Yes. He has already
Served in court which will be बाकी usual order कर देवे CDCA confirmation letter. Learned counsel for the appellant filed an affidavit of the advocate's clerk wherein it is mentioned that food election je petitioner date of occurrence ବେଳକୁ
ସେ ତଳେ ଥିଲା ମୁଁ ଦେଇଛି ସାର୍ଟିଫାଇଡ କପି ଆରଟିଆଇ ରେ ଯୋଉଟା ପାଇଛି ସେଟା ବି ଦେଇଛି ଦେଖ 13/7 ର occurrence
Paragraph 4 they have stated, Your Lord. Of the
Paragraph 4.
affidavit. Yes, Your Lord.
affidavit ra
Again.
that the said documents prove that acha date of occurrence के बेगी
13/7 11/7
11/7
11/7
that that the petitioner that the appellant could them appellant was in Surat jail
from 4/16/16/7
during the period from 4/6/2011
to 16/7
to 16/7/11. Learned counsel for the appellant submits that the date of occurrence is kebe
13/7 13/7/11
13/7/2011. The copy of the affidavit has been handed over to the learned counsel for the state. Will take some time also to obtain instruction on the documents filed along with the affidavit. Free copy of the order be handed over to the learned counsel for the state. Same order in
47
item number 47.
Man.
Eta hochi 46 ro 47 টা দিলে না
date is same
affidavit file extra copy this CDCA. Yes.
Item 48.
48, Mr. Panda.
In this case, the petitioner is custody in an optional section, Malad 363, 376, 3, 376, 2, and
Notice.
586. And STC.
Fresh case, Your Lord.
Grace matter.
Notice, my lord.
Extra copy to be served, notice to be issued. CDCA to be opened. Call the passover matters, then we'll. कहे हाँ आसी आनिलेनी कौन सी आनिलेनी ओके
item 161 the mistake in originally भूल ना होता
अच्छा ये कौन सा है भूल नंबर तक पे नहीं ठीक है कितने नंबर आइटम
161
ଆଉ ଗୋଟେ କୋର୍ଟରେ ସେଇ ନମ୍ବରଟା ମାଇଣ୍ଡରେ ରହିଯାଇଥିଲା
161
yes
that is CRLA number 946
yes.
of 2022.
And in my earlier application, my lord,
Wait, just. This is not your first application.
This is my second application. not first. That is my earlier application, CRLA number 1129 of 2022. I had order dated 23 of 2023. My lord to renew his prayer for bail after examination of the eyewitness.
Which is that application? CRLA?
Earlier
Earlier application.
1129 of 2022.
In view of the specific overtact attributed against the appellant to have caught hold of the deceased at the time of occurrence by restraining his movement while the another co-accused stabbed the deceased by a knife, I am not inclined okay. So summon the eyewitnesses, examine them. You are at a liberty to renew the prayer after the examination of the eyewitness. Yes, what is the position of the...
Here, my lord, 3 eyewitnesses are there, my lord. One is the my lord informant, Madhav Singh, and in the meantime, my lord, he has been passed away, died, my lord. And then, my lord, 2 other, my lord, Sebati Biswara and my lord Suraj Biswara.
Sebati?
Biswara, my lord. And my lord, Sebati Biswara. Then another name is my lord, Suraj Biswara.
Suraj,
my lord, S-U-R-A-J. Biswara. I annexed, my lord, their deposition, my lord. That
page number?
running page, my lord, 17 to 23, my lord.
This man...
They examined, my lord, PW1 and 2, my lord. এই 3 জন eyewitness as per my instruction, my lord.
Sebati is examined as PW1.
One.
What he has stated against you?
Hostile, my lord.
Not supported.
Not supported, my lord.
And what about the other eyewitness?
She, my lord, hostile.
Yes, he is PW?
2, my lord. Running page 21.
Yes, Mr.
Yes, my lord.
Are the learned counsel for the petitioner, learned counsel for the state, learned counsel for the appellant, learned counsel for the appellant submitted that the appellant is in judicial custody since
24/12/2021.
24/12/2021, and he has been charge sheeted under section
302 and other allied offenses.
Under section 302 IPC and other allied offenses. He further submitted that when the appellant approached this court for the first time for bail in CRL number 1129 of 2022, as per order dated 23/2023, taking into account the specific overtact attributed against the appellant by the eyewitnesses, the bail application was rejected. Our liberty was granted to the appellant to renew the prayer for bail after examination of the eyewitnesses in the trial court. Learned counsel for the appellant submits that in the meantime, trial has commenced and there are 3 eyewitnesses to the occurrence. The informant Madhav Singh is dead. Yes. The other 2 eyewitnesses, namely Sebati Biswar and Suraj Biswar, being examined as PW1 and PW2 in the trial court, have not supported the prosecution case and they have been declared hostile. And therefore, the bail application may be favorably reconsidered. Peer you the evidence of the eyewitnesses annexed to the criminal appeal memo. Learned counsel for the state also submits that the eyewitnesses have not supported the prosecution case. Considering the submission made by the learned counsel for the respective parties, the change in the circumstances after the rejection of the earlier bail application, the fact that the eyewitnesses being examined in the trial court as PW1 and PW2 have not supported the prosecution case, and further taking into account the period of detention of the appellant in judicial custody, I am inclined to reconsider the prayer for bail and direct the petitioner to be released on bail allowed.
Obliged.
I beg pardon, my lord. Item 21, Passover. I am in BC, at Puri.
Jagannath Darshan Salani. Yeah. So you go. Okay.
Offense under 307.
Just a minute. Yes, what is the date of custody? Mr. Counsel.
11th 12 2022.
Okay. What are the offenses under which charge sheet submitted?
That's 341,
Just go slowly. 341.
324,
Yes.
326,
Yeah.
307, SC/ST Act 3 2 VA.
302 convert ହେଇନି?
No.
What is the name of the injured?
And
What is the name of the injured?
Nilambara Behera.
Nilambar Behera.
Yes.
What are the injuries sustained?
There are 3 injuries sustained.
Yes.
One is stab wound on left back, lacerated wound on knee, laceral wound at left knee.
No, ଗୋଟେ stab wound ଟା କୋଉଠି କହିଲେ?
On left back.
Left back, yes. Then
lacerated wound on both knee.
Lacerated wound both knee. ଆଉ କଣ ଅଛି? CA ଅଛି କି?
previous in what?
Yes.
କେତେଟା କେସ୍ ଅଛି?
ଗୋଟେ ଅଛି ଡେଲେଙ୍ଗା PS କେସ୍ ନମ୍ବର 85.
କେବେକାର?
ଏଇଟା ହଉଛି 22 20/3/22.
What is your name?
ନାଁଟା କୁହନ୍ତୁ ଆପଣଙ୍କର?
ଅକ୍ଷୟ କୁମାର ସୁବୁଦ୍ଧି.
Akshay Kumar Subudhi, Hard Mr. Akshay Kumar Subudhi, Learned Counsel for the appellant. Learned Counsel submit that the appellant is in judicial custody since 11/12/2022. He has been charge sheeted under section 341, 324, 326, 307 of the Indian Penal Code and section 32BA of the SC/ST PO Act. And the injured has sustained 3 injuries, out of which gote injury grievous na gote?
Yes.
Out of which one stab wound has been opined to be grievous in nature, while the other 2 on the both the knee have been opined to be simple in nature. And in view of the nature of acquisition, the bail application may be favorably considered. Learned counsel for the state opposed the prayer for bail and submitted that the case diary revealed with the petitioner that the appellant has got 1 criminal antecedent. Considering the submission, nature of acquisition against the petitioner, nature of injury sustained, period of detention of the petitioner in judicial appellant, I'm inclined to release the appellant on bail subject to condition that he shall not try to tamper with the evidence, shall not indulge in any criminal activities, and appear before the learned trial court on each date. The case would be posted for trial. Violation of any terms and conditions and until cancellation of bail allowed. Yes.
Item number 33.
Here, the petitioner has been charge sheeted for the offences punishable under sections 341, 143, 147, 148, 323, 326.
Just a minute.
I have
number 33. CRLA 1102/2023. So what is the custody date?
Custody managed in 27/9/23.
Charge sheet submitted.
Mallet.
What are the offences?
Offences mallet 341, 143,
341,
143.
Yes.
147. 148. 323. 326. 307. 294. 506. 120B. 149. 25 and 26 of the Arms Act. Section 3(1)R. 1S. 2V. 2VA of the SC and ST Prevention of Atrocities Act.
How many injured persons are there?
1, madam.
What is the name of the injured?
Injury is pilot Jagannath Karma.
Jagannath?
Karna, my lord.
What are the nature of injuries?
Injuries, my lord, I have annexed, my lord.
10 injuries are there.
No, my lord. I have annexed, my lord, annexure 4, first, page 27.
Fracture injury is there, first one.
Proximal.
Okay.
Right.
Femur is there, fracture. Then right hand. Then head, left side. So many fracture injuries, 4, 5, 5, 6. What is the weapon of assault?
My lord, blunt weapon as well as my lord, firearms. But my lord, initially.
No, you are the only accused or other persons?
Other accused persons. My lord was pleased to release other co-accused persons. My lord may
What
see.
that overtact attributed against you is that
I have
you
used a firearm, my lord. And all entire occurrence has taken place. They say he at the instance of the present petition. Political dispute ballot was
Mr.
Yes, my lord.
If this
no,
firearm, he has used the firearm only.
Ballot subsequently, I have our next ballot. We kindly see. This is the first injury report, which was given on 21/6/2023, my lord. This report, my lord, dated 21/6/2023.
This annexure 4.
Annexure 4, page 28.
Then
subsequently, around 3-4 months of the occurrence, again the victim was forwarded. Ballot requisition was issued. Ballot may see page 30. 30. My lord, the report is for 4/7/2023.
Yes.
Well, let me see the injury, my lord. Punctured wound over the lateral aspect may be inflicted by firearm and grievous injury. Proximate leg wound over the medial aspect of left proximal leg and one stab wound. That was found after 4 months of the occurrence. And that is on 4/7/2023. Report is there.
4/7/23.
My lord. My lord.
No, initially that injury was not there.
It was not there in my page 28, my lord, the first injury report.
No, please come to the item number 10. Puncture wound achi pura nai kon.
My lord, this was the injury report, first stab wound over the same again. The second report was given on, and my lord was pleased to consider the case of the co-accused persons, including the dying declaration of the injured. My lord has referred it in detail. While considering the application, my lord,
no, the injuries are there. That injury item
there.
number 10 is in that first report 21.
It was there in serial number 10, not 9.
And the same injury is there in also
in the second report.
one.
Yes. My lord was
the other injuries may be not possible, so obviously. So, Mr. Tripathi,
yes, my lord.
ये जो 10टा इंजुरी ହେଇଛି ଆପଣଙ୍କର ଯଦି firearm injury ପାଇଁ ଆକୁ responsible କରୁଛନ୍ତି, then he would be responsible for this item number 10, that 21/6/2023 ର ଯୋଉ ରିପୋର୍ଟଟା ଅଛି। ଆପଣ କୋଉ ରିପୋର୍ଟଟା ଧରିଛନ୍ତି injury ରିପୋର୍ଟଟା?
injury report ମୁଁ 4/7/23
ସେଇ ଯୋଉ 4/7 ର ଯୋଉ ଗୋଟେ injury ହଉଛି ନା,
puncture wound over the
same ଜିନିଷଟା 21/6 ରେ ତାଙ୍କ ପିଟିସନ ଦେଖନ୍ତୁ। ତାଙ୍କ ପିଟିସନ ର ପେଜ ନମ୍ବର ରେ ସେ ଦେଇଛନ୍ତି 28 ପେଜ ରେ। Come to page number 28. There are two injury reports. He was examined twice, once on first time on 21/6/23. This item number 10 is that very injury.
Yes.
Punctured wound, right? So obviously the other injuries are not possible. These are fracture injuries, etc. So what he says that the other co-accused persons have been released on bail. Where is the bail order?
The person who has been named by the injured as the main accused in the dying declaration, my lord has considered that In page, my lord, may I have annexed that order? Page 88, my lord, may see. While considering bunch of applications with regards to other accused, page 88.
They have also been named by the injured to be the appellant.
My lord. And the dying declaration is very specific. My lord, I consider that.
What about the criminal antecedent,
My
Mr.?
lord, that I have given, my lord, an affidavit at the last occasion. Comprehensive affidavit I have given. That is valid. Bargot PS case number 371 of 2012 for offences under 147, 148, 185, 294, 53, 427, 506 by 149. Bargot, all cases are old cases. 2 cases of 2012, 3 cases of 2021. Minor offences. That is there in Flag B, minor.
Notice sufficient, Mr.
Yes, my lord. But the two person fire gun shot. One is Rinkesh Mishra and this person. Rinkesh Mishra. Whether the Rinkesh Mishra has been enlarged or not.
Yes, sir.
No. If your case is that two persons fired gunshot at the injured, then there is only one injury which can be caused by firearm. So who is responsible for that? Whether it is that Rinkesh
That will
Mishra,
come out of at the trial, my lord.
right? So you are not sure that whose gunshot caused that injury.
Yes.
Are the learned count Mr. D.P. Dharlan, senior advocate appearing for the appellant, land counsel for the state. Land counsel for the appellant submits that the appellant is in judicial custody since 27/9/2023 and he has been charge sheeted under section so and so. He further submits that the co-accused persons have already been released from bail by this court in CRLA as a number. Co-page rachi se order gudago? Annexure 7 series. Lekhi devo 7 series page 84, है ना? And the injured has sustained number of injuries, out of which only one injury is possible by firearm, which is stated to have been used by the appellant. However, it is also the case of the prosecution that co-accused Rinkesh Mishra also fired gunshot at the injured, and therefore the prosecution is not sure as to under by whose firearm the sole injury found on the injured on the left proximal leg, left lateral aspect of the leg is possible, though it has been opined to be grievous in nature. And therefore the bail application may be favorably considered. Learned counsel for the state oppose the prayer for bail and place the statement of the injured Jagannath Karma. So also the injury reports dated 21/6/2023 and 4/7/2023. Considering the submission made by the learned counsel for the respective party, nature of accusation against the petitioner, period of detention of the petitioner, appellant in judicial custody, release of the co-accused persons on bail. Gotekar line the learned counsel for the state submitted that the appellant has got criminal antecedent. The learned counsel for the appellant has filed the comprehensive affidavit relating to the status of those cases. Considering the submission, so release of the co-accused persons on bail and period of detention in judicial custody. I am inclined to release the petitioner on bail, condition that he shall appear before the learned trial court on his date, and the case should be posted for trial. He shall not indulge in any criminal activities, shall not try to tamper with the evidence. Violation of any terms and conditions shall entail cancellation of bail allowed.
Next item, my lord, item number 34 is also the co-accused, but no specific allegation against him. No antecedent.
Okay. The same case.
Same case.
Okay, and his period of detention?
Same. 27.
The same lecture, but no, এটা जो अच्छी ना firearm से portion टा omit कर देवे. खाली देवे no specific overt act has been attributed, and similarly situated co-accused persons have been released on bail. What about the criminal antecedent?
One antecedent matter I have given, my lord. 1323 case, year 2017.
One criminal antecedent is there opposed to, बाकी सब same करे allow.
Item number 35.
Mr. Bhansdev.
Item 31, just matter after lodge matter the file is just
okay. Password को launch for it.
Okay. Submit file is there.
That one.
Well, here my lord.
Wait.
Item 35.
And who is appearing for the informant? You are appearing, all right. What is the date of custody?
4/7/2023, my lord.
Charge sheet submitted.
Charge sheet submitted, page 13, my lord. Under section page 13, 341, 354B, 326, 307, 294,
Okay.
3 ACS.
What is the name of that injured?
Well, injured is the informant, namely
Lakshmi Naik.
Lakshmi Naik.
And injury?
Injury, my lord.
There are 3 injuries.
Yes.
2 are grievous. 3 are grievous.
All the 3 grievous?
Yes.
What is the part of the body on which the injuries were caused?
Leg. That's on the leg.
Who part of the body of
the Lekhinad?
Lekhinad gini. Mason kale?
Left leg.
Wait.
Right leg or left leg?
Mera TB of right leg, left leg achi. So, what about criminal antecedent?
Criminal antecedent, my lord, 2, my lord, I have been released on bail. 1 of 2015 and another 2020.
What is the weapon of assault?
That is assaulted by means of
Mr. Tripathi.
Harsa. Allegation is that
Harsa.
So you assaulted a lady and she has sustained
this is not first time, Miller.
3 grievous injuries.
This is the not first time.
Okay.
ଆଗରୁ ବି ସେ ଗୋଟେ ସେଇ କେସ୍ ଆକୁ ମାରିଥିଲା and he was forwarded to
କାହାକୁ ମାରିଥିଲା?
this victim.
No, then you cannot get bail. So what is the case number?
33 of 2000.
33 of 21.
33.
Yes.
Of
Baghamari PS case number 33 of 21.
Then it's amount to misutilization of liberty, that bail should be cancelled, the other bail. Same injury.
Yes,
Yes.
ma'am. Same victim.
Are the learned counsel for the petitioner, learned counsel for the state?
If you permit me, kindly hand over the photocopies.
The pass on for me. The learned counsel for the informant. The learned counsel for the appellant submit that the appellant is in judicial custody since 4/7/2023, and he has been charge sheeted under section 341, 354B, 326, 307, 294 of the Indian Penal Code, and section 31W L W1 Roman 1 তারপরে bracket ভিতরে 2 bracket ভিতরে VVA of the SC/ST annexure 2 ଅଛି page 13 ଦେଖିଲେ କି, and the injured has been discharged from the hospital and therefore the bail application may be favorably considered. The learned counsel for the state opposed the prayer for bail and submitted that the injured is a lady and she has sustained as many as 3 grievous injuries. And earlier, the appellant assaulted the injured informant, for which Baghamari PS case number 33 of 2021 was instituted, and he was released on bail, and he misutilized his liberty. Therefore, it should not be granted bail. The learned counsel for the informant area produced some photographs which is stated to be that of the injured victim. Considering the submission made by the learned counsel for the respective parties, taking into account the nature and gravity of the accusation, since the petitioner has misutilized his liberty and assaulted a lady whom he had earlier assaulted, for which a PS case was instituted, I am not inclined to release the petitioner on bail. Stands rejected. Liberty is granted to the petitioner appellant to renew the prayer for bail after the examination of the injured in the trial court. Shall learn in trial court. The case shall be learn in trial court shall expedite the framing of the charge and at the first instance take steps for examination of the injured. Yes.
Yes.
Item number 49.
49, Mr. Ramesh Chandra. 2234 of 2023. This is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 84 days in filing this CRLA. After going through the averments taken in the interim application hearing the Land and Council for both the parties, I am inclined to condone the delay. Accordingly, delay in filing the CRLA is condoned. IA is disposed of.
Obligement.
The matter will be listed for admission next week. Yes.
My lord, I am in this matter from the VC, Lordship.
Item number 52.
In item 52. Lordship, there are two criminal appeal, 604 and 605 of /21. Lordship, on the last date of hearing, we had undertaken to file the paper book. But the main issue is with us that the applicant accused in jail, their family is from the state of Telangana, and we are in Delhi, and we are not getting any assistance from the local advocates at the trial court level. So we are unable to get those documents. So we have filed one IA, Lordship, for seeking permission to exempting from filing the paper book. Lordship, our IA pertains to only hearing on the bail and suspension of sentence, and my humble submission is that paper book is necessary only if the hearing is on appeal is on the merits. For bail and suspension of sentence, that it is not necessary, since the impugned order and the evidence is already on the judicial file, Lordship. So I will request your Lordship to kindly fix any date as your Lordship deems fit, since he is in jail from 23/7/2019. Almost
number 2487 of 2023, hard Mr. Sam Manohar, virtual, who submits that even though he made a submission on 18/9/2023 that the appellant is ready and willing to prepare the paper books and file it. But the appellant is facing a problem for which it would not be possible on his part to prepare the paper book and file the same, and therefore he may be exempted from filing the paper book. Land Council for the state has no objection. The prayer made in this IA is allowed. Now the office is to prepare the paper book serially. The Land and Council further submit that the interim applications listed for bail and stay realization of fine be considered. Put up this matter next week, along with CRLA number 605 of 2021. All right.
That's it. I'm deeply obliged.
Yes.
Item number 53.
May I please, Your Lordship?
There are two matters, Mr. Sahu. In both you are.
Madam,
Yes, sir.
the appellant have been convicted for the offense in the 20B2C for a period of 10 years and fine of rupees 1 lakh. And in the meantime, two other co-accused have already released on bail by this court, my lord. The appellants are custody since long, my lord. From the date of
what is the period?
10 years. From the
10
date,
years sentence is.
my lord.
What is your period of detention?
My lord, my period is
You are taken into custody on same day or on the other?
same day.
LCR টা বার করলেন?
25/6/2015.
Wait, let me the final form to us. না কোন আরো কুমার মণি কহর।
কুমার মণি কহর and সুরু কহর।
Wait. কুমার মণি কহর কস্টোডি ହେଲା 26/6/2015। তারপরে আরোটা না গেল
সুরু কহর।
Same date. So
Madam.
both are on same day. So you are not released on bail
Never
during.
released on bail, madam.
देखिए
Local.
Custody.
शुरू कहाँ more than 8 years.
You are right that they were never released on bail. And in this criminal appeal, have you ever been released on bail?
No, my lord. Custody certificate shows that they were never released on bail.
So এটা ହେଇଯିବ ଆପଣଙ୍କର 8 years and
3 months.
3 months, 4 months. So 8 years, 4 months. No, 5 months here. 8 years, 5 months. The sentence is 10 years.
My lord.
And where is that bail order of the?
My lord, I was.
यार एक case रो co-accused order.
My lord.
Yes, Mr. Mishra. Gotcha. Are the learned counsel for the appellant, learned counsel for the state. The learned counsel for the appellant submitted that the appellant was taken into judicial custody on 26/6/2015 and they were never released on bail during trial. And during pendency of the appeal also, they have never been released on bail. And as such, they have already undergone 8 years and 5 months of substantive sentence out of 10 years of sentence imposed by the learned trial court. He further submits that some of the co-accused persons, namely so and so, have already been released on bail by this court. Therefore, bail application of the appellant may be favorably considered. He files the copies of the bail orders which are taken on record. Learned counsel for the state oppose the prayer for bail. In the case of say Mohammed Muslim ro jora ye sera quote kar dega. Last paragraph लिखिए considering the submission made by the learned counsel for the respective parties. The sentence imposed by the learned trial court, the period already undergone by the petitioner in judicial custody, the release of the co-accused persons on bail, and further taking into account the ratio laid down by the Honorable Supreme Court in the case of so and so, I am inclined to release the petitioner on bail. ये कोडिया लोको
Man of local
region जाको
region जाको.
देखो front page पर सिले
District of Both, Bangshuni PS.
कुमार मणि हल्ला बहुत अच्छा सुरु कुमार हल्ला बहुत ठीक है
All of them from both.
हाँ ठीक
मतलब sterilization of time.
sterilization bail allowed sterilization of fine connected case study भी है ना?
Malo.
Yes.
Item number 55.
Mr. Biplab Kumar Das. Rest of the matter will take up after lunch.
My lord, on item in the weekly list 2,279. The admission matter. Because they have been admitted next week. The supplementary list, may I pray?
Right. On କହୁଛନ୍ତି କେତେ କହିଲେ? କିଅ କେତେ ନମ୍ବର କହିଲେ? ହଁ 17 କହିଲେ? କେତେ ନମ୍ବର କହିଲେ?
207.
ମାର୍କ କର। What do you want?
The appeal has not been admitted, my lord.
Okay.
And the prisoner has given a petition from the prison to change the lawyer. That may be accepted and fine may be stayed, my lord. The LCR is attached. For bail, another date may be next week or in date your lordship please. Fine stay any or admit it.
Have you filed your Hinama?
My lord.
That is in the name of the earlier engaged counsel. Where is your Hinama?
My Bakalatnama is also there. It is there. Even
Right,
noting is given in the list.
Reduce the prisoner's petition at flag F for engagement of Mr. Parikita Panda in place of previous counsel. Wakalatnama has already been filed by Mr. Panda and his associate. The names of the newly engaged counsel be reflected in the cause list henceforth in place of Ananta Narayan Patnaik. What is the sentence imposed here?
10 years, man.
I'd admit call for the trial court record.
Trial court record is already there.
Where?
See, I would have case asked they should tag similar matter there.
Acha. It appears that the trial court record has been called for. A trial court record has been received in CRLN number 616 of 2022. Henceforth, this criminal appeal be listed along with CRLN number 616 of 2022. You have filed the bail application is there. So have you supplied the deposition copies?
I have not.
The deposition copies be supplied to the Land and Council for the state. Place this matter would have date the IE for consideration of both the applications. Yes.
I may be pardoned, my lord. May I prefer Passover item 53 to take up?
Yes. It has already been admit collected.
Stay of the last.
That will be considered afterwards. Yes. All the matter serially.
Item number 57.
Please, my lord. My lord, the petitioner is also languishing in jail custody since, my lord, 28/2/2017 against the, my lord, the sentence awarded for 10 years under section 304 part 2. My lord, the operating page is page 17.
What is the last order?
There was a direction to produce the custody certificate.
Yes.
I have it, Your Lordship. He has been in custody throughout the trial.
Yes.
In after conviction, and he has been in custody for a total of 7 months and
7 years. Out of 10 years.
7 years and 2 months.
2 months.
Aja, and the sentence imposed is
10 years.
Earlier, your bail application has been rejected.
No.
Hmm. IA number 2203 of 2023. This is an application for bail. The Learning Council for the state has produced the custody certificate of the appellant, which indicates that as on 3/11/2023, the appellant has remained in judicial custody in connection with this case for 7 years and 2 months. The sentence imposed by the Learning Trial Court, the substantive sentence imposed by the trial court is 10 years. The appellant was earlier granted interim bail and by this court, and after availing the same, he surrendered at right time. Considering the submission made by the Learning Council for the respective parties, the nature of accusation, the sentence imposed by the Learning Trial Court, the period already undergone, absence of any chance of early hearing, I am inclined to release the appellant on bail allowed.
Right.
Item number 58.
But appellant to be convicted under section 304 part 1 IPC.
You have supplied deposition
Yes.
copy?
Running case 39.
Just a minute. Yes, operative part of the judgment pays
38 is the conviction and sentence is 39. While acquittal
running page or internal page?
running page 38, internal page 30 of the victim judgment.
Okay.
He was acquitted from the charge.
10 years, 10,000 in defaults 1, so 304 part 1.
Part. When I'm in custody.
And you were on bail during
No,
that?
throughout I'm in custody since.
So what is the date of?
Surrender. I surrender on 10 to February 10 to 2016.
You were never released on
Never,
bail?
I was only granted interim bail by the Honorable Court during appeal.
When?
And I surrender in time. I was,
No, when you were?
I was granted interim bail on 19/12/2022 and surrender in time. File the surrender certificate. I'm in custody for more than
केबे bail ଦେଇଥିଲେ? 1912.
19/12.
4 months, 3 months.
3 months.
That means if it is 16 means 7 years and এটা হব 9 মাস ହେଇଥାନ୍ତା but 3 মাস କଟିଯିବ, so 7 years 6 months. Sentence total is 10 years, no?
10 years.
Yes, Mr. Mishra, 10 years to 7 years 6 months ରହିଲାଣି.
Only want to bring to your lordship notice order dated 27/6/20.
27/6/2022.
23, your lordship. 27/6/2023.
23?
My lordship. 27/6/2023, your lordship.
There is no such order. There is an order on 3/7/23 in which I pass the order that since earlier one coordinate bench has disposed of the bail application, a full bench decision was quoted and it was referred to the Honorable Chief Justice to place the matter before appropriate bench. But the minutes has come that it is to be taken by the assigned bench. So heard the learned counsel for the petition, learned counsel for the state, learned counsel for the petitioner submitted that the petitioner is in judicial custody since 10 to 2016 and he was never released on bail during trial. And during pendency of the appeal, as per order dated 19/12/2022, he was granted interim bail for a period of 3 months. And after availing the same, he surrendered at right time. And as such, out of 10 years of substantive sentence imposed by the London Trial Court, the petitioner has already undergone sentence of 7 years and 6 months, and there is no chance of early hearing of the appeal. Balance of convenience is in his favor, and therefore the bail application may be favorably considered, and counsel for the state oppose the prayer for bail. Considering the submission nature of evidence adduced, sentence imposed by the trial court, period already undergone by the petitioner in judicial custody, absence of any chance of early hearing, and conduct of the petitioner in complying with the terms and conditions of the interim bail order, I am inclined to release the petitioner on bail allowed.
Item number 61.
Gitanjali S. Das.
Item 60. The appellant is convicted on RI for 10 years and a fine of rupees 1 lakh.
Judgment relevant page is page number
31.
31 bar karo.
Internal is 30.
Internal page 31. Running page is
10 years. RI for 10 years and 1 lakh.
running page was
Page 31. Not see.
okay. 10 years 1 lakh in default to undergo RI for 20B2C. So you are taken into custody when?
I was in custody on the that is 11/9/2020.
11/9?
20.
2020. So you have not undergone half of the sentence. So here is the question of grant of bail. You move afterwards. I am just keeping this matter pending. Learned counsel for the INAJO 1781 of 2022. This is an application for bail. Learned counsel for the petitioner 6 for an adjournment. List this matter in February 2024. IN number 1782 of 2022. This is an application for stay of realization of fine. After hearing the learned counsel for the respective parties, let there be stay of realization of fine pending disposal of the appeal. Yes.
Item number 62.
Yeah, for Mr. Ponda next week, my lord.
Okay. Surrender certificate not filed? Have you surrendered or not?
Let it come next week.
No, just a minute. What is that order?
10/7/2020. Last
3 months that was granted in 10/7. So that period has already expired. If you have, all right, a mention is made on behalf of Mr. Devasis Panda
He is on accommodation.
for adjournment. It appears that the petitioner was granted interim bail for a period of 3 months in IN number 1881 of 2022 as per order dated 10/7/2023. And the learning counsel for the petitioner was asked to produce the surrender certificate of the petitioner. No surrender certificate has been produced. Let instruction be obtained from the Learning Trial Court, that is additional session judge cum special court under POCSO Act, Parampur Ganjam, in GR case number 43 of 2017 oblique TR number 88 of 2022, whether the petitioner availed the interim bail order as per order dated 10/7/2023 of this court or not, and if so, whether he has surrendered at right time, and if not, what steps have been taken against the petitioner for his arrest and also against the bailers. The copy of the order be sent to the Learning Trial Court by the Registered Judicial through email. Report be furnished, matter be placed in the week commencing from 11th of December 2023. Yes.
Item number 63.
My lord, kindly have a glance to the order dated 18/10/23.
Supplied the names, address, documents of two local sureties. Acha, sei dino dele apan. Now he has to verify about the genuineness and bailers and authenticity of those documents.
I have sent the letter and I tried to contact the IAC. Couldn't know next week.
Next week. All right, Learning Council for the state submitted that some more time may be granted for obtaining instruction regarding the genuineness of the local sureties, so also the authenticity of the documents filed by the Learned Counsel for the appellant put up this matter in the week commencing from 4th of December 2023.
I beg your pardon, my item 22, surrender certificate has already been filed.
Not filed लिखा है
In the registry, it is already filed.
अच्छा सेटा
I
काटी दिया
obtained it, sir.
केबे कहि परिबे कि the Learned Counsel for the it is submitted on behalf of Mr. Devasis Panda that surrender certificate has already been filed. Let the registry place the same on record. Yes. आगोटा काटी देवे पूरा
Item number 64.
Mr. Raut,
May I please? Last occasion, Lordship direct to obtain the address verification report.
लोग को कोटी करो
West Bengal.
आनी लगी so and so address of ଆଉ ଗୋଟେ ଜାଗାକୁ shift ହେଇଗଲାଣି so how many years you are in custody?
Custody since 5/3/17.
You have never been released on bail
No, ma'am.
during so 6 years and 8 months. Sentence imposed is 10 years, no?
10 years, ma'am.
Okay, that will. But what about the local sureties? Have you given that?
No, my lord. I
So
installed the lower court advocate, my lord. Lower court advocate said that if Lordship directed, then he will.
no. You give it here like other cases. You are to
Yes,
hand
my
over
lord,
the.
I already instructed them, but they said if court order is there, then I will.
Okay, the London Council for the. अच्छा इटा लिखूंगा IA number 2067 of 2068 of 2022. This is an application for bail. As for the order dated 24/7/2023, the London Council for the state has produced the written instruction received from additional SP on Gold dated 13/9/2023, wherein it is indicated that though the address furnished by the appellant in the cause title is correct, but at present the family has shifted to another place and the address of that place has been mentioned. The report is taken on record. Let the Land Council for the petitioner further submits that the petitioner is in judicial custody since 5/3/2017, and as such he has remained in custody for 6 years 8 months out of 10 years of sentence imposed by the Land Trial Court. Let the Land Council for the petitioner supply the names, address, and documents of 2 local sureties who are interested to take the petitioner on bail to the Land Council for the state, on receipt of which the instructions shall be taken from the inspector in charge of Jarapada police station regarding authenticity of the documents filed. So also the
Jarapada place.
Jarapada, and also about the genuineness of the bailers. So matter to be listed, go to saptah chhad do, free copy of the order be handed over. So you hand over during course of this week.
Yes, sir.
During course of this week, he has to hand over.
Next week, ma'am.
Next week.
Yes.
Then it will come on 18th. By 4th kar do. By 4th of December 2023, you give it, okay?
Oh, yes.
Later, written instruction taken on record. Yes.
Item number 66.
Item 66, my lord, on behalf of Mr. Kishore Mishra, matter may be taken up next week, my lord. He has filed power that has not come on record, and my lords have directed him to file an affidavit. He is filing today. Lordship may call it next week, my lord.
Our name may be deleted. Ranjan Kumar Pradhan.
କାହା delete ହବ କୁହନ୍ତୁ
Ranjan Kumar Pradhan and association.
ସମସ୍ତଙ୍କ ନା
ଆଜ୍ଞା ତାଙ୍କ ନାଁ ଆସିନି
ମାନେ ଏଇ ଯୋଉ AK ପ୍ରଧାନ SR ଆଚାର୍ଯ୍ୟ ସବୁ delete ହବ
yes sir.
ହଁ କିଏ ଫାଇଲ କରିଛନ୍ତି
किशोर कुमार मिश्र एंड एसोसिएट्स
କେବେ ଫାଇଲ କଲେ ଅଛି ଓକେ he has already filed Bhina.
already filed.
Right. It is stated at the bar that Mr. Kishore Kumar Mishra, advocate and his associates have filed Vinama for the appellant. The Learned Counsel engaged earlier for the appellant submits that their names may not be reflected in the cause list henceforth. The registry shall place the registry shall place the Vinama on record. The names of the earlier engaged counsel, that is Ranjan Kumar Pradhan and his associates, shall not be reflected in the cause list henceforth. What about the number 2? There's a connected matter. But you are not one. Number 2 to release this matter along with so and so. Order of yes.
Item number 67.
May plus. The appellant has been convicted on the running page 31(1) of
Mr. Agrawal, the contentions which are raised by Mr. Mishra, your associates are taking note of it. Yes, because most of the time you are also not. Yes, it's all right.
Man. It's entitled. I was placing paragraph 34.
That evidence of that
Returning officer
returning officer
PW3.
PW3, yes.
That's a big paragraph.
Yeah.
Continues from 38 to 48.
No, your main contention yesterday was that this PW3 was their witness, but in spite of that, he has answered most of the question in favor of the respondent.
And against the...
Okay, right. And he
election.
has not been declared hostile.
Yes.
And his evidence is to be accepted. And his statement rather indicates that whatever omissions are there in that nomination or in that affidavit has been, a scope has been given to correct the same. Nomination is concerned, he said that it is not of substantial nature and
He has ignored it and
verified he ignored it because of his power which is there under 33(4) of the RPR.
Mine.
That was it.
In that context,
Yes.
your lordship put certain material questions to the witness at page 42.
Yes.
PW3. To court. Your lordship got it? Fine. Whether there was any objection to the nomination of the respondent on the day fixed for the scrutiny of nominations. The answer is no.
Yes.
In subsection 4 of section 36, question.
Yeah.
In subsection 4 of section 36 of the RPR 1951, it is indicated that nomination paper of a candidate shall not be rejected on the ground of any defect which is not of a substantial character. Whether anywhere it is mentioned, what is the defect of a substantial character? Answer. According to me, clause 6.9 of chapter 6 scrutiny of Handbook of Returning Officer, exhibit 38 indicates insufficient grounds for rejection of nomination papers. At present, I cannot say in which other places of any act or rules the defect of a substantial character has been defined. Now, my lord, your lordship may turn to the next page. After exhibit BJ, same page, right? In the same bunch, the original declaration made by the respondent while submitting the photograph of the candidate dated 2/4/2019 is there, which is in one sheet, and the same is marked as exhibit BK. This is the signature, address, telephone number, and date given by the respondent in exhibit BK, which is marked as exhibit BK by 1. After exhibit BK in the same bunch, the original checklist of documents in connection with filing of nomination granted by me in favor of the respondent on 2/4/2019 with respect to the nomination serial number 2, which has been received by the respondent on 2/4/2019 at 11:45 p.m. at Kotak is available, which is in one sheet, and the same has already been marked as exhibit 39/2. I have mentioned in Exhibit 39/2 against its serial number 1 against the document affidavit in Form 26 that not as per the prescribed format, column serial number 5, 6, 7 and 8 not properly mentioned. I have mentioned in Exhibit 39/2 against its serial number 2 against the document certified extract of electoral roll when the candidate is an elector of a different constituency as NA. I have mentioned in Exhibit 39/2 against its serial number 3 against the document Form A and B applicable in case of candidates set up by the political parties as yes. I have mentioned in Exhibit 39/2 against its serial number 4 against the document copy of caste certificate if the candidate claims to belong to SC or ST as NA. I have mentioned in Exhibit 39/2 against its serial number 5 against the security deposit whether made as yes. I have mentioned in Exhibit 39/2 against its serial number 6 against the document oath and affirmation whether taken as yes. In Exhibit 39/2 after serial number 1 to 6 there is a heading. The following document which has not been filled up should be filed, which have not been filed should be filed as indicated below. Against its item number A, the gaps have not been filled up by me and I have put dash mark. Against item number B, I have put a tick mark and thereby the candidate has been directed to submit the received affidavit with columns duly submit the revised affidavit with columns duly filled up before the commencement of scrutiny of nominations, failing which the nomination paper will be liable to be rejected. Against item number C, I have not filled up the gaps and I have put dash marks. Here your lordship puts a question. Question. According to you, as per Exhibit 39/2, there was only one defect in the nomination paper bearing serial number 2 filed by the respondent, and that was the incomplete affidavit in Form 26, which was not in prescribed format. Yes. Exhibit 39/2 was prepared in original as well as in duplicate by me. The original checklist was kept in the bunch of the first set of nomination paper of respondent bearing serial number 2 LA 2019. The duplicate of the checklist was handed over to the respondent and he received the same on 2/4/2019 at 11:45 AM by putting his signature, which is one sheet, and the same is marked as Exhibit BL, which was earlier marked as Exhibit XY. My signature, date and seal appearing on Exhibit BL is marked as Exhibit BL/1, and the signature, date and time and place of the respondent on Exhibit BL is marked Exhibit BL/2. The format of the checklist has been prescribed by the Election Commission of India in Exhibit 38 at page 76 and 77. Being a returning officer, I cannot alter or modify the format of checklist, and I have only to fill it up after receiving the nominations from the different candidates and after preliminary examination of the same. Annexure 11, which is available in page 357 to 362 in Exhibit 38, which is already marked as Exhibit 38/3, is the Form 2B, that is nomination paper part 5th and 6th of Form 2B are the part of nomination paper in Form 2B Exhibit 38/3. These two parts were not exhibited by the election petitioner, and it has been exhibited by us. After Exhibit 39/2 in the same bunch, Exhibit 6 of Form 2B, which is receipt of nomination paper and notice of scrutiny, granted by me on 2/4/2019 in favor of the respondent Muhammad Makim with respect to nomination serial number 2LA19 is available, which is one sheet, and the same is marked as Exhibit BM. This is my signature, date and seal appearing on Exhibit BM, which is marked Exhibit BM by 1. I handed over a copy of Part 6 similar to Exhibit BM to the respondent on 2/4/2019, which is marked as Exhibit BN 1 sheet. This is my signature, date and seal appearing on Exhibit BN, which is marked as BN by 1. In Exhibit BM and Exhibit BN, I have indicated that the nomination paper bearing serial number 2LA19 filed by the respondent was delivered to me by the respondent on 2/4/2019 at 11:20 a.m. for the election from 19 Baravati Kotak Assembly constituency. I have also further indicated that all nomination papers will be taken up for scrutiny at 11 a.m. on 5/4/2019 at office of the Sub-Collector Sadar Kotak. Both Exhibit BM and Exhibit BN are part of nominations in Form 2B. Form 2B, that is Exhibit 38/3, consists of 7 parts in total, which are Part 1, Part 2, Part 3, Part 3A, Part 4, Part 5, and Part 6. A candidate set up by this is material, your Lordship may kindly take note of this. A candidate set up by a recognized national political party or recognized state political party for the concerned state is required to use Part 1, Part 3, and Part 3A of the nomination paper in Form 2B, and such candidate is not required to use Part 2. A candidate not set up by recognized national political party or recognized state political party for the concerned state is required to use Part 2, Part 3, and Part 3A Form 2B. In Form 2B Exhibit 38/3 above, Part 1, there is an instruction strike off Part 1 or Part 2 below, whichever is not applicable. In Exhibit 38/3, under Part 1, at its beginning, there is an instruction to be used by candidates set up by recognized political party. According to me, strike off and delete means the same. The candidate set up by recognized political party can strike off or delete Part 2 of Form 2B, Exhibit 38/3. In Exhibit 38/3 under Part 1, there is a provision to propose the name of the candidate by one elector of the concerned constituency, and the proposer has to put his signature at the space provided under Part 1. At the beginning of Part 2 in Exhibit 38/3, that is Form 2B, there is instruction to be used by candidate not set up by recognized political party. Under Part 2 in Exhibit 38/3, that is Form 2B, there is provision to propose the name of the candidate by 10 electors of the concerned constituency, and there is also provision for putting signature of those 10 elector proposers. Part 4 and Part 5 and Part 6 of Form 2B, Exhibit 33, are to be filled up by me as returning officer and not to be used by the candidate. After Exhibit BM in the same bunch, there is photocopy of checklist. Documents in connection with filing of nominations with respect to nomination serial number 2 filed by the respondent, which is one sheet and already marked as Exhibit 39/3. Exhibit 39/3 is the photocopy of Exhibit BL. After Exhibit 39/3 in the same month, the original revised affidavit in Form 26 dated 3/4/2019 of the respondent is available, which is in 27 sheets, has already been marked as Exhibit 43. Now, your Lordship's query have been answered by the returning officer. Question. From whom you received Exhibit 43, that is revised affidavit in Form 26 dated 3/4/2019, which is dated 3/4/2019, and when? From the respondent, and that too on 4/4/2019. How did Exhibit 43 came to the bunch of the nomination paper bearing serial number 2 LA 2019? After receiving Exhibit 43 from the respondent on 4/4/2019, I put it in the bunch of the nomination paper bearing serial number 2 LA 2019. Please see Exhibit 43 and answer as to when and from whom the respondent purchased the stamp paper. The document in Exhibit 43 stamp paper indicates that it was purchased on 30/3/2019 from one Prasanta Kumar Das stamp vendor. Please look into Exhibit 43 and answer whether it contains at what time on Exhibit 3/4/2019 the affidavit was shown before the notary public. After verifying Exhibit 43, the witness answers no. Then, Milord, after Exhibit 43 in the same bunch, there is original checklist of documents in connection with filing of nomination granted by me to the respondent with respect to nomination paper serial number 2345 LA 2019 RO, which is one sheet, and the same is already marked as Exhibit 47. After preparation of Exhibit 47 in original and in duplicate, I handed over the duplicate copy to the respondent on 4/4/2019, which has been handed over by me and received by the respondent on 4/4/2019 at 12:20 p.m. at Cuttack. The duplicate checklist of document in connection with filing of nominations granted by me to the respondent with respect to the nomination paper serial number 2345 LA 2019 RO, which is one sheet, is marked as Exhibit BP, earlier marked as XY. This is my signature date seal appearing on Exhibit BP, which is marked as Exhibit BP by 1. The signature date and time of respondent appearing on Exhibit BP is marked Exhibit BP by 2. I have mentioned in Exhibit 47 as well as in Exhibit BP that the affidavit in Form 26 with all the columns filled up as yes, and the affidavit has been shown before notary in serial number 1, and since documents under serial number 2, 3, 4, 5, and 6 have been earlier complied with on 2/4/2019, I have mentioned NA.
Exhibit 43, that is the revised affidavit in Form 26, was filed by the respondent in time. After Exhibit 43 in the same month, the forwarding letter of the respondent dated 3/4/2019, enclosing therein the revised affidavit is there, which is one sheet, and the same is marked as Exhibit BQ with objection. The signature of the respondent in Exhibit BQ is marked as BQ by 1. The respondent, while filing Exhibit 43, also filed 3 sets of photocopies of 43 duly attested by notary public to be true copy, which I kept in nomination paper serial number 3 LA 2019, 4 LA 2019, 5 LA 2019 respectively. And those attested photocopy of the revised affidavits have already been marked as Exhibit 44, 45 and 46 respectively.
There is no necessity of placing further because
Minor.
So what is your
only a little bit. Thereafter, your lordship may kindly come below. After receipt of the revised affidavit on 4/4/2019 from the respondent, I made scrutiny of all nomination papers. Your lordship got it?
Yes.
Minor.
So what is your submission, Mr.
Submission is, if your lordship will go through the evidence of PW3, who is their witness, it will be abundantly clear that their allegations with respect to Form 2B has been denied expressly.
Form to be, they have stated that something has been deleted.
Part 2 has been
Part
deleted.
2, yes.
ତାରି ଉପରେ ବି ସେ କ୍ୱେଶ୍ଚିନ୍ ପଚାରିଛନ୍ତି, ମୁଁ ପଚାରିଛି, ସେ କହିଛନ୍ତି, ସେଇଥିପାଇଁ ମୁଁ ପ୍ଲେସ୍ କରିବାକୁ ଚାହୁଁଛି.
And the other parts, one part has been mentioned, the other part is not there. That last towards last.
Part 3 and with respect to Part 3 and Part 3A. I am going to place those paragraphs. I made scrutiny of all nomination papers of all the candidates on 5/4/2019, which date was earlier fixed and notified by the Election Commission of India for scrutiny of nominations. On 5/4/2019, at the time of scrutiny by me, the representative of the election petitioner as well as the representative of the other candidates were present. At this moment, I cannot remember whether any candidate himself was present at the time of scrutiny or not. I gave opportunity to all the representatives, including the representative of the election petitioner present at the time of scrutiny, to verify the nomination papers and other accompanying documents filed by all the nominated candidates, including the respondent. None of the representatives of any political parties or independent candidates, including the representative of the election petitioner, raised any objection with relation to the deletion of Part 2. That is their allegation in the nomination paper in Form 2B or any part thereof submitted by the respondent in nomination serial number 2, 3, 4 and 5.
No, Mr. Misra, suppose nobody raised objection. Even the election petitioner
has a duty.
But
that duty bound.
Suppose that is the opportunity is to be given. But even if they have not raised objection, but if the court finds that the defects which are been there in that nomination paper
were of substantial nature,
so that can be taken into account.
Lordship can substitute your lordship's finding with that of the finding of the returning officer.
So whether they have complained, not complained, that's one aspect.
That is immaterial. And with that respect, your lordship has put specific questions.
Yes.
I am placing that.
Nobody has raised an objection. That is clear. Even
whether 38 paragraph 38, page 67 to 69. Whether it is intimated to the public in general from which date, time and place the nomination papers for the election would be available. You also got
Yes, yes, I got it. Page 60.
The answer
60.
is no.
Yes.
How a candidate will get the nomination paper? The nomination paper is made available to the candidate in the office of the returning officer, and the candidate can also download the nomination paper from the website of the Chief Electoral Officer, Orissa. What is the procedure if a candidate wants to collect the nomination paper from the office of the returning officer? Answer. By filing a plain paper application indicating the numbers of nomination papers required in the office of the returning officer, the candidate can collect the nomination paper. Question. Whether while collecting the nomination papers from the office of the returning officer any seal, signature, date are given on it? Answer. No. Whether while downloading a nomination paper from the official website a candidate is legally permissible to make any alteration, deletion, modification, tampering of the same and file it after filing of the same. It's not permissible.
So what is your submission on this particular question and answer?
ଚାରିଟା ଜିନିଷ ସେ କହିଛନ୍ତି କୋର୍ଟ ପଚାରିଛନ୍ତି ଅଲ୍ଟରେସନ ଡିଲିସନ modification and tampering.
Here is a case of deletion, let us say.
Here is only a case of deletion of part 2.
Right.
That already it has been explained by the returning officer that it is not required for respondent, number one.
No, Mr. Misra, once he says that it is impermissible.
Yes.
This deletion, whatever you download, you fill it up, and deletion is impermissible.
Yes.
If he says that if the deletion is not of substantial nature,
yes,
then I have the power under 33(4) to just ignore it. Whether these two statements are not contradictory to each other.
No. It is just explanatory to each other, and the returning officer on your lordship's query and on my query has answered that latter. I will place that.
Just a minute. So I'm just framing the, making a query to you. The question that has been put by the court is that since in this case he has downloaded the nomination paper from the official website of the Election Commission of India, I put a question specifically that whether it is legally permissible. I am excluding others, whether it is to delete any part of it and file it up. He says that it is impermissible.
It is not permissible.
It is not permissible. Previously, he has stated that the nomination paper of the candidate, that means of the respondent which was received by me, in that nomination paper, these are the things which has been omitted, particularly part, he has admitted that.
Yes.
But he tries to say that since it is not of substantial.
He says it is not relevant.
Relevant. It is not relevant. Substantial or relevant?
He said, since it is not relevant and the defect is not of a substantial nature.
Right, defect is not of substantial.
If it is at all treated to be a defect, since it is not of substantial nature, I ignored it under 33(4).
Okay, I'm just one step ahead that how can these two statements be reconciled with each other? That's all I want.
Yes.
Once he says impermissible, I put that whether legally permissible wording has been used. He said, no, it is impermissible. Then under any stretch of imagination, it is not permissible.
Yes.
So how, if he says in one line like this, how it is not that...
Ordinarily, it should not have been done. Ordinarily, your lordship may mark that it should be strike off. Alteration, deletion, ଆପଣ ଚାରିଟା ଜିନିଷ ପଚାରିଛନ୍ତି.
ଏଠିକି ରଖୁନ, ସିଆଡେ କୁଆଡେ ନେଇ ରଖୁଛ? Just let us 33(4) କୁ ଟିକେ ଆସୁଛି.
ଆଜ୍ଞା. On the presentation of a nomination.
ସେ ଗୋଟେ ଟିକେ ପଢନ୍ତୁ ଟିକେ.
On the presentation of a nomination paper, the returning officer shall satisfy himself that the names and electoral roll numbers of the candidate and his proposer as entered in the nomination paper are the same as those entered in the electoral rolls. Then the proviso comes. Provided that no misnomer or inaccurate description or clerical, technical or printing errors in regard to the name of the candidate or his proposer or any other person or in regard to any place mentioned in the electoral roll of the nomination paper, and no clerical, technical or printing error in regard to the electoral roll numbers of any such person in the electoral roll or the nomination paper, shall affect full operation of the electoral roll or the nomination paper with respect to the person or place in such as to be commonly understood. And the returning officer shall permit any such misnomer or technical description, misnomer or inaccurate description or clerical, technical or printing error to be corrected where necessary. Direct that any such misnomer, inaccurate description, clerical, technical or printing error in the nomination electoral roll or in the nomination paper shall be overlooked.
So these two can be reconciled in the sense that nothing has been stated in 33(4) about power of ignoring any deletion. What has been stated that if there is any inaccurate description, clerical error or technical and printing error, chapela bale kichita omitted, so that can be just overlooked.
Overlooked.
But if something has been deleted from the to the knowledge of the election petitioner. It has been deleted.
Yes.
Whether it would be relevant or not relevant, it is a matter which is to be assessed by the returning officer, that whether this particular paragraph is relevant or not.
He is in his power as a returning officer. He considers this deletion.
Which one?
Part 2.
No, part 2, he considers its deletion. He said
not
that
to be relevant.
No. Provided he may say so, but question is that suppose in the statute does not empower him. Statute, what the statute says according to 33(4), what he can condone.
33(4) is one part.
Yes.
But he, as a returning officer, he has inherent power.
No. Inherent power, unless the statute gives him the power. So where from he will get that power to accept? Suppose then only in other case it will be a 10-page nomination paper. In one case it may be a 3-page nomination paper. So whether those 7 pages which have been deleted, whether those are relevant or not, according to the candidate, it may be irrelevant. But ultimately it is to be decided by the returning officer that yes, these are irrelevant, so or relevant, that is to be adjudicated.
That question,
yes.
Here the returning officer decides
Yes.
that it is relevant.
Yes.
Whether it is relevant or not relevant, that has also been decided by the apex court.
No, I'm not. I'm asking you that in view of 33(4), where is that power lies with the returning officer to condone if there is any deletion. That is why he rightly submitted that as it appears that if the candidate deletes something, it is legally impermissible. If it is legally impermissible and 33(4) does not say that he has the power to condone if there is any deletion. Please try to explain me. It is a case where you let us say it is whether it is strike up or so. Let us say that strike up and deletion is the same. Let us accept.
To your lordship is
yes
are twofold. The proviso, 33(4) and the proviso read together had got 2 parts. One part relates to electoral roll.
That yes.
Your electoral roll.
Yes.
The other part relates to nomination paper.
Right, I'm on the nomination paper. Nomination paper re madhya
here he respects to both the things, both to electoral roll as to the nomination
ठीक
paper.
अछि nomination paper रे जदि एई गुडाक जिंसो थिबो, misnomer थिबो, inaccurate description थिबो,
with respect to nomination, if your lordship reads it with respect to nomination at one part and electoral roll to another part, then under this proviso, subsection 4 and proviso to it, the returning officer has the power.
No. आपणकर डिलीशन टा एई जो 5टा जिंस मते क्लियरली कहंतु देखो एई जो डायरेक्ट दैट लेट अस से लास्ट 3 लाइन हमें पढुछु डायरेक्ट दैट एनी सच मिसनोमर येला नंबर 1 inaccurate description number 2 clerical number 3 technical number 4 printing error number 5 in the electoral roll or in the nomination paper.
Yes.
हैला तेणु
दीटा कथा कहू
हाँ दीटा जाक कथा वी आर ऑन नॉमिनेशन पेपर तेणु एई 5टा जाक जिंस जदी थिबो
नॉमिनेशन पेपर भी जदी थिबो
हाँ ताकू ओवरलुक करिवार करि परिबो हमर एठी नॉमिनेशन पेपर रे
ही अछि
नॉमिनेशन पेपर अछि कोन अछि ना डिलीशन अछि एई जो डिलीशन एई जो 5टा कोउटा भीतर पडियो मते कोन
सेटा टेक्निकल एरर रे भी जीवो क्लरिकल मिस्टेक रे भी जीवो दीटा जाकर जीवो माय सबमिशन टू योर लॉर्डशिप subject to what your lordship will
No, no, that's it.
decide.
I'm opening up. I'm opening up.
Your
That so
lordship
that you
is
can, I
quite-
can, I'm. Question is that no such specific question has been put by either party. I'm again harping. ये जो डिलीशन टा क्लरिकल और टेक्निकल भितर पड़ियो बेली आपण आनी नांती कि सी भी आनी नांती आनी जनी मते देखता
हां देख एटा काढ तेज नहीं नहीं सेटा कोन जोटी पचारले कोट सेटा आगे कोन
अन्य आडू बुलांतुनी मते
नहीं
सीधा प्रश्न पचारुची
आगे
सीधा
आगे
उत्तर दे
आगे एग्जैक्टली सही जगह ना मतलब देखा
सो इलेक्शन आउ थरे क्लारिफाई कर दवा यदि इलेक्टोरल रोल हो किंबा नॉमिनेशन पेपर हो ता देरे पांचटा जिंस अछि ताहले ताकू कंडोन करिवार ताकू ओवरलुक करिवार पावर रही रिटर्निंग ऑफिसर से पांचटा जिंस वाला एक रे हला मिसनोमर दुई रे हला इनाकुरेट डिस्क्रिप्शन तीन रे हला क्लरिकल चार रे हला टेक्निकल पांच रे हला प्रिंटिंग एरर तेणु प्रश्न होउची ए जो डिलीशन हेची नॉमिनेशन पेपर रे ए पांचटा भितरु को भितरे डिलीशन आसीबो आ सेटा कोनोसी साक्षी आपनकर रिटर्निंग ऑफिसर होंतु बा आउ की होंतु सेमति किछि कहिचंती की से विषय
I took note of your lordship's question.
ओके किछि नै खाली कहबा आपन किछि जस्ट एग्जामिन इट
Kindly come at present.
Yes.
I beg to invite your lordship's kind attention to page 118.
Say PW3 ro 118 का स्लो
Second subparagraph.
just
ता पूर्वरु अन्य जो क्वेश्चन गुडा पचारि आसीचु सेगुडा से थाकेरे पड़ी आसिले एटा को आउरी रेलेवेंट लागिवो तथापि मु एग्जैक्टली पिन पॉइंटेडली आपन को क्वेश्चन को देखौछि proviso to subsection 4 of section 33 of the RP Act पाइला ना 1951 provides that as returning officer I can permit any misnomer or inaccurate description or clerical, technical or printing error to be corrected and when necessary direct that such misnomer, inaccurate description, clerical, technical, printing error in the electoral roll or in the nomination paper to be overlooked. By exercising my power conferred under proviso to subsection 4 of section 33 of the RP Act. And I have overlooked the alleged defects deletion.
Era gote sentence. By exercising my power conferred under the proviso to subsection 4 of section 33 of the RP Act,
I have overlooked the alleged defects deletion, omission in the nomination paper in form 2B of the respondent as the same were not defects of substantial character. And such alleged defect, deletion, omission being coming under the category of misnomer, inaccurate description, clerical, technical or printing error as a returning officer, I have overlooked this. ମୁଁ ଯୋଉ ଯାଉଛି ଏଭିଡେନ୍ସ ଟାକୁ ପ୍ଲେସ୍ କରି କରିକିରି ଏଇଟାକୁ ବି ଆସିଥାନ୍ତି
ନାଇଁ ଗୋଟେ ଗୋଟେ ବେଳେ ବେଳେ ଷ୍ଟ୍ରାଇକ୍
ବେଳେ ବେଳେ ଷ୍ଟ୍ରାଇକ୍ କରେ ସେଟା ବି ସାଙ୍ଗେ ସାଙ୍ଗେ ଆନ୍ସର
ସାଙ୍ଗେ କ୍ଲାରିଫାଇ କରିଦେଲେ ବେଟର.
କାଇଣ୍ଡଲି ପ୍ଲିଜ ଟେକ୍
Yes, I have already taken note. Yes.
Then ମୁଁ paragraph 52 at page କୋର୍ଟ ଯୋଉ କ୍ୱେଶ୍ଚିନ୍ କରିଥିଲେ ମୁଁ ସେଇଠିକି ଆପଣଙ୍କ ପେଜ ମୁଁ କହୁଛି 67 to 69 at page 68.
68
ଆପଣଙ୍କ क्वेश्चन ଟା ମୁଁ ପ୍ଲେସ୍ କରୁଛି. Whether it is intimated to the public in general from which date, time and place the nomination papers from the for the election would be available? No. How a candidate will get the nomination paper? Answer. The nomination paper is made available to the candidate in the office of the returning officer, and the candidate can also download the nomination paper from the website of the Chief Electoral Officer, Orissa. Question. What is the procedure if a candidate wants to collect the nomination paper from the office of the returning officer? Answer. By filing a plain paper application indicating the number of nomination paper required in the office of the returning officer, the candidate can collect the nomination paper. Question. While collecting the nomination papers from the office of the returning officer, any seal, signature, date are given on it? Answer. No. Whether while downloading a nomination paper from the official website, a candidate is legally permissible to make any alteration, deletion, modification, tampering of the same and file it after filling the same. It is not permissible. If your lordship leaves it to me, these are pertinent questions to be asked by the election petitioner. But however, wherever either party,
I have exercised my power under 165 of the evidence. Yes. Yeah.
Your lordship has wherever there is any vacuum,
right,
your lordship has tried to fill it up.
Yes. I just wanted to know that what is the correct state of affairs. Yes.
Whether in the official website of Election Commission, the Form 2B in which the respondent has filed his 4 sets of nomination papers bearing 2, 3, 4, 5, Exhibit 42, 39, 40, 41, 42 was available in this manner? No. Please verify Exhibit 39, 40, 41 and 42 and tell which parts have been omitted by the respondent while filing the same before you on 2/4/2019. In all the nomination papers 39, 40, 41 and 42, Part 2, Part 3C II and Part 3 after its clause E, this subpara. I further declare that I am a member of the scheduled caste. These are omitted. ଏଇଟା ବି ଆପଣ ପଚାରିକିରି କାଢିଛନ୍ତି. Then your lordship may come to paragraph 39.
So just take pause for a moment. So now this जो answer टा देला एटा clear कला जे what have been deleted from the nomination paper. Each set of nomination paper. এবং तार जदियो गोटे क्वेश्चन को सी कहूची जे एटा लीगली परमिसिबल नुहे कोनोसी डिलीशन हेले नॉमिनेशन पेपर रे आ गोटे जगह रे कहूची जे 33(4) रे जो पांचटा पावर रही
ता भितर मोर
मोरटा
पावर
करिया को मु सेही पावर को यूटिलाइज करी किनी ये ओमिशन गुडा को मु ताकू तारी भीतर आसुचे एवं मु सेही पई याकू ग्रहण कली
because it is not of substantial. Correct.
right. So that was the state. Yes.
Yes. Now, my lord, then questions were put to the returning officer with respect to nomination filed by the election petitioner.
Leave it that. That's
Comparison, for comparison.
I beg to place the same only for the purpose of comparison. जो प्रकार डिफेक्ट अच्छी बेली कि सी आम नॉमिनेशन रे दर्शाउचंती similar defects are also available within
no, at least in their nomination paper whether anything has been deleted.
No, other defects are there.
No, we are on this deletion part.
On deletion part.
Deletion part nahi. Okay. Yes.
तथा मैं प्लेस कर दूँ अरे गोटिए सेट कर देले सेम रिलेट्स टू अदर 3 पार्ट्स आमे भी एथरे जो कलु सेटे केवल गोटिए सेट कलु चारटा जाक सेट रिपीटेशन होबो बोली
No, you may say Mr. Mishra, you may say that these are also the defects in the nomination paper of the election petitioner. In spite of that, he accepted. So he is maintaining uniform standard.
Uniform standard?
Question is that whether that standard which has been maintained by the returning officer is legal.
Is he entitled to do it under law?
Right. One thing. So because the election.
And second, whether it is substantial in nature.
Because their case is not under challenge. They are
No.
So
we are not saying that.
Right.
We are only placing it for the purpose of comparison.
Oh.
He has placed at the behest of the respondent to belie that allegation. We are saying he has followed a uniform standard.
Okay, but simultaneously we also agree that they are, so far as deletion is concerned, that is not at least.
That is not there. ଆଉ ଅଦର ସେଟ ଯଦି କହିବେ ମୁଁ ପ୍ଲେସ୍ କରିବି ନହେଲେ ଆକୁ ଛାଡି
No, you leave it just. Yes.
Then paragraph 50 के आसिया देखिए kindly come to paragraph 50.
Because once you cross that, then we'll go to that affidavit because there are many things are to be say.
नहीं ଆଉ ଗୋଟେ ମଝିରେ ଅଛି ଯେ ଫର୍ମ ସେକ୍ସନ 7B ରେ paragraph 7B ରେ ତାଙ୍କର ଆଲିଗେସନ ହଉଛି 3 ତାରିଖରେ affidavit ମୁଁ 2 ତାରିଖରେ ଫାଇଲ କରିବି.
अच्छा, okay. So you
sequence ରେ ସେମିତି ଗଲେ that will be better.
नहीं.
After 2B, I will come to their allegations under paragraph 7B.
Okay. ये जो 2 तारीख affidavit.
अभी 2 तारीख रे affidavit जमा हमें देइनु सेटा मु प्रूव कर देली ताकरी exhibit रू जे ना हमें देइछु.
But no, I think there is a again I am that if there would have been no affidavit in on second, then what is the question of preparation of checklist?
Preparation of checklist.
Okay, that checklist preparation which has been exhibited, that itself indicates that there was something on or there was an affidavit on, and it was a computer which was not taking up both the affidavits. So he once you mention
exhibit गुड़ाक भी मु प्लेस करिछि से जोटा को exhibit करिचंती सेही तरह अछि जे 2 तारिख रे affidavit ता 2 तारिख रे फाइल हेतला.
But some defects were noticed for which opportunity was given, checklist was given, and preparing that he came in on 3rd or 4th to rectify that defect. That was the case. All right, we will see that. So now about this defects and omission, what other statements or what other paragraphs relating to this form 2B you want to place?
Paragraph 50 at page 95 to 98.
Paragraph A. 95?
95 to 98.
Yes.
ତାପରେ ଆଉ ଗୋଟା ପ୍ଲେସ୍ କରିବି paragraph 55.
ନା ଆପଣ
Most important ଟା ପ୍ଲେସ୍
ହଁ ଯୋଉଟା ଆପଣ
ମୁଁ 50 ରୁ କରୁଛି କାହିଁକିନା it contains your lordship's own question.
Okay, okay.
Paragraph 50 at page 95 to 98.
Got it. Yes.
After presentation of the nomination paper either by the candidate or by his proposer as returning officer, I am required under law to serially number each nomination paper on the first page of the nomination paper with date and exact time at which it was received. The nomination received by me shall be serially numbered as number, LA, year, arrow. This provision has been prescribed in the Handbook of Returning Officer, Exhibit 38 under its Chapter 5, Nomination, Clause 5.10.4 at page 74. I have meticulously followed this provision.
Yes.
After endorsing serial number on each nomination paper as returning officer, I am required under law to advise the candidate to take oath or affirmation immediately after presenting each nomination paper and in any case not later than the date previous to the date of scrutiny. I have meticulously followed this provision. The oath or affirmation for election to the state legislature is required to be subscribed by the candidate under Article 173A of the Constitution of India. This provision has been prescribed in the Handbook for the Returning Officer, Exhibit 38 under its Chapter 5, Nomination, Clause 5.17 at page 85 to 87. The most relevant clauses are 5.17.1, 5.17.2, 5.17.4, 5.17.5, 5.17.6, and 5.17.8. I have meticulously followed these provisions. I hope these clauses will not be required to be placed before your lordship because your lordship has already gone through this.
Yes.
I have meticulously followed the provisions under Section 33(4) of RP Act 1951, read with the provisions prescribed in the Handbook of Returning Officer, Exhibit 38 under Chapter 5, Nomination, Clause 5.11.1 at page 75 and Clause 5.13 at page 81 and 82. After preliminary examination on the technical standpoint as a returning officer, I have prepared the checklist of documents in connection with filing of nomination of each candidate for each set of nomination in original as well as in duplicate. The format of checklist is available in the Handbook for Returning Officer in Exhibit 38 under Chapter 5, Nomination, Clause 5.11.2 at page 76 and 77. The original checklist is to be kept with the nomination paper of the concerned candidate, whereas the duplicate of the checklist is to be handed over to the candidate. Along with the checklist as a returning officer, I have handed over the Part 6 of Form 2B to the candidate, which is the receipt for nomination paper and notice of scrutiny, mentioning therein the serial number of the nomination paper, the name of the candidate, and at what date and time I received the nomination paper, further intimating therein the date, time, and place fixed for scrutiny of all nomination papers in compliance with the provisions of law prescribed under Section 35 of the RP Act 1951, read with Clause 5.15 of Chapter 5 Nomination of Exhibit 38, along with the duplicate checklist and Part 6 of Form 2B duly filled up by me as a returning officer I have also handed over the certificate of receipt of oath, certifying therein that the candidate has subscribed oath and affirmation as required under Article 173A of the Constitution of India before me at my office, mentioning the date and time of taking oath and format of the form of oath and affirmation is available in Exhibit 38, page 384. This instruction has been given as per clause 5.17.9 in Exhibit 38 aspect 87, which I have meticulously followed. This follows your lordship's questions. What is the date of scrutiny of nomination paper of all the candidates? 5th April 2019. Did you fix any time for scrutiny, and in this case, what is the time and up to which time it continued? Yes, I fixed the time for scrutiny of all the nomination papers at 11 a.m. at the office of the Sub-Collector Kotak Sadar, and accordingly I started it at 11 a.m. and by afternoon it has been completed. Whether at the time of scrutiny of the nominations paper of any candidate, the said candidate or all the candidates, proposers, representatives were allowed to remain present? Yes. At the time of scrutiny, all the candidates, proposers, representatives were allowed to remain present. How many sets of nomination papers you scrutinized on that day? Apart from 90 Baravati Kotak Assembly constituency, I was also the returning officer for 91 Chaudhar Kotak Assembly constituency, and that day also the scrutiny of the nomination papers of all the candidates of 91 Chaudhar Kotak Assembly constituency was held. Question: whether you were alone scrutinized all the nomination papers filed for these two constituencies or anybody else was assisting you? A team of officers were assisting me under my direct supervision. Question: whether any objection or defect was pointed out to you during the scrutiny of nomination paper in Form 2B of the candidates by anybody? Nobody has raised any objection or pointed out any defect or a discrepancy before me in respect of any candidate during the scrutiny of nomination papers in Form 2. This also includes the respondent. Whether after scrutinizing the nomination papers of all the candidates you declare which sets of nomination papers are valid, or merely because no objection was raised by anybody, you declare the nomination papers to be valid? That is a very pertinent question, which has been left to be asked by either of the parties. My Lord has put that question. After scrutinizing all the nomination papers in accordance with law, here is a positive statement. I scrutinized it. I scrutinized it in accordance with law. I gave my decision as to which set of nomination papers of the candidates were valid. When did you declare the list of validly nominated candidates after scrutiny? On the same day, that is on 5th April 2019, I also published the list of validly nominated candidates in Form 4, which is as per the prescribed format at page 347 of Exhibit 38, paragraph 52, page 99 to 102. Photocopies of nomination papers should I continue?
Go.
Paragraph 52 at page 99 to 102. Photocopies of nomination papers filed by each candidate along with photocopy of the affidavit in Form 26 accompanying the nomination should be displayed on my office notice board on the same day on which the nomination has been filed as per clause 5.20.1 of Exhibit 38 as at page 88. I have followed these instructions meticulously. To quote, whether in the Case of the respondent, you as a returning officer displayed in your office notice board the entire bunch of nomination papers filed by the respondent in his 4 sets of nomination papers, or you only displayed the Form 2B and affidavit in Form 26? I displayed the photocopies of the entire bunch of nomination papers filed by the respondent in his 4 sets of nomination papers in my office notice. If anyone furnishes in information contradicting the statements in nomination form 2B or affidavit in form 26 by means of a duly sworn affidavit, copies of such papers were also required to be displayed by me on my office notice board, and I have meticulously followed it. Question: whether either the election petitioner or any person on his behalf or anyone had furnished any such information contradicting the statements in the nomination papers in Form 2B or affidavits in Form 26 filed by the respondent by the Exhibit 39, 40, 41 and 42, that is 4 sets of nomination papers in Form 2B and 39 by 1, 40 by 1, 41 by 1, 42 by 1, that is affidavits in Form 26 dated 2/4/2019, as well as Exhibits 33, 43, 44, 45, 46, that is affidavits in Form 26 dated 3/4/2019 by means of a duly sworn affidavit before you know. If anyone asks for photocopy of nomination papers in Form 2B and affidavits in Form 26 filed by any candidate as per the provision of Clause 5.20.1 of Exhibit 38, page 88 and 89, I, as the returning officer, am required to make the same available to him or free of cost. I have also meticulously followed this provision. As returning officer, I am required to hand over photocopies of the nomination papers in Form 2B and its accompanying documents, including the affidavit in Form 26, filed by each candidate to the media persons for wide dissemination of the information contained therein as per the provision of Clause 5.20.1 of Exhibit 38, page 89, and I have meticulously followed this provision. As per Clause 5.20.2 of Exhibit 38, page 89, as the returning officer, I am required to furnish the photocopies of the affidavits in Form 26 filed by the candidates to the district election officer at the earliest, who will consolidate all such affidavits in his district and make available of the same to any person or persons desirous of obtaining the same on payment of copying charges, and I have meticulously followed this provision. As per Clause 5.20.2 of Exhibit 38, page 89, as the returning officer, I am required to uphold both the nomination in Form 2B, upload both the nominations in Form 2B as well as affidavits in Form 26 filed by the respective candidates in the website of Election Commission of India soon after the candidate filed the same, which can be viewed by the general public, and I have meticulously followed this provision and uploaded the nomination papers in Form 2B as well as in the affidavit in Form 26 dated 2/4/2019 of the respondent on the date when he presented the same. I have also uploaded the affidavits in Form 26 dated 3/4/2019 of the respondent filed on 4/4/2019 on the same day, that is 4/4/2019, in the official website of the Election Commission of India. While uploading the affidavits in Form 26 dated 3/4/2019 on 4/4/2019 filed by the respondent, the latter affidavit, the affidavit in Form 26 dated 3/4/2019 overrided the earlier affidavits.
That is the statement.
My lord. Earlier affidavits in Form 26 dated 2/4/2019 filed by the respondent. The earlier affidavits in Form 26 dated 2/4/2019 of the respondent was incomplete, and the same was irrelevant for the purpose of giving complete and correct information to the electors, and as such, the same was required to be replaced. The latter revised affidavit in Form 26 dated 3/4/2019 filed by the respondent on 4/4/2019 is available in the website of Election Commission of India, which is relevant for the purpose of giving correct, complete and correct information to the elector.
No, Mr. Mishra, just take pause for a moment. ये जो first sentence ला कोयला से paragraph रो.
No.
The earlier affidavit in Form 26
My lord.
dated 2/4/2019 of the respondent was incomplete.
Again.
And the same was irrelevant for the purpose of giving complete and correct information to the electors. तामाने जोथि पाई से
रिजेक्ट कर लेता
हाँ नहीं नहीं जो opportunity देला ना
थोड़ा दबा को कहले
and as so the same was required to be replaced.
Again.
So the wording used is replaced.
हाँ.
It's not that
overrided.
It's a two different things.
हाँ, नहीं ये जो replace
Overrided means once you feed the second affidavit, the first affidavit automatically goes. But this word has been used as if he removed that.
He removed that
and only placed that second affidavit.
No, the first statement
ये जो दीटा sentence
ये
रहुଛି ना
जो replaced कहले
हाँ
सेटा inadvertently made.
हाँ कारण replace माने total अलगा जे
हाँ.
ये नीचे आजी
Yes, ma'am.
काढ़ी आनले
It is absolutely correct.
कारण ये
Here it means that he himself replaced.
हाँ right that is माने
The other is
previous
that the configuration is such
हाँ
that the
right
earlier will overwrite over the
हाँ right that is ସେଇଥି ପାଇଁ ଦୀଟା ଯାକ sentence ଦେଖିଲେ जे first sentence ଟା ସାଙ୍ଗରେ ଏଇଟା
it has to
tally
be
କର
understood in
हाँ.
the light of the earlier.
Okay, so we are taking pause for today. We will continue. हाँ अच्छा ओ हाँ एटा complete कर ठीक है
ଆପଣଙ୍କ relevant question जो ଆଜି ଥିଲା
हाँ
ସେଟା paragraph 55 ର ଅଛି
we will just I'll remember I'll continue हाँ এই paragraph ଟା शेष कर देंगे
Okay. Before the commencement of scrutiny of nomination, that is 5/4/2019 at 11 a.m., the nomination forms in 2B, that is 39, 40, 41, 42, and the affidavits in Form 26 dated 3/4/2019, Exhibit 43, 44, 45, and 46 filed by the respondent were very much available on my office notice board with the media persons in the office of the district election officer Kotak and in the official website of Election Commission of India for view by the general public. In spite of availability of nomination papers and affidavits of the respondent to the general public in the aforesaid manner, as stated by me in the previous paragraph, nobody, including the election petitioner or his agents or any of his supporters, filed any affidavit,
raised any objection
before me to the nomination paper and affidavits filed by the respondent before or during the scrutiny of nomination. तांकर जो first stage रे जो right ता थिला to object, that they have not availed. Now tomorrow at 3.
से 3 टा बड़ा
खाली गोटाए रिक्वेस्ट अछि 1 तारीख रे my associate will not be there, so that I will be handicapped.
Okay, tomorrow we'll just take it to 4th. Okay.
Yes.
Just a minute. हाँ 3 टा बोलो. The list is remaining packed, so the division bench. So unless I
we are
some
also aware of the sentiment of the bar member.
हाँ तेणु तांकर जदि single bench matter किछि न निया जीवो, so that would not be so.